second item will be taken up first, 117.
हाँ,
It will become one group, 117, 118, 119, 120, 121, 267.
हाँ,
I am for the respondent matter.
right.
My question is at page number 6. Whether on the facts and circumstances of the case, the learned ITT was justified in holding that the proceeding 153A
Ah.
without jurisdiction.
Now covered by Kabul Chawla.
My lord,
Yes,
it is a Punjab High Court. See page 4, my lord.
Page 4 of
That writ petition or the ITA.
Ah.
That reference is also made to the decision of Honorable Punjab and High Court in the case of Jai Bhagwan Om Prakash versus Director of Inspection, and the decision of Madras High Court in the case of Deorajan and other video is very important. Copy of judgment may kindly. Where it is specifically mentioned that
No, but what about the later judgments?
the government land.
they specifically mentioned anywhere that in the fact and surplus business pattern to achieve that is only with the view to evade the revenue and hoodwink the authorities. The name of the farm has been created, would make search of petitioner farm premises on basis of such warrant in the north.
Whereas, if you permits me, I'll just explain 5 minutes the facts.
हाँ,
Facts are, my lords, the respondent before lordship is a society carrying on educational activities. In 2008, there was a search without any warrant in the name of the society. They seized the materials. Then 153A search assessment proceedings were initiated. Then my lords, demands were raised. I carried an appeal. I was unsuccessful. Now, before the Income Tax Appellate Tribunal, I raised for the first time that there was no such warrant in the name of the society. What the tribunal did, tribunal remanded it without following that NTPC judgment, 229 ITR, page 349. Then, my lords, I appealed to the High Court. This honorable court, by the judgment, I am giving the copy, they don't. I am giving the judgment, my lords. Lordship may kindly see that the reported case of this respondent in 336 ITR, page 112 and para 9. This, of course, my learned friend has not mentioned it. Para 9, my lords may kindly see. We are of the view that in absence of search warrant in the name of an SSC, search conducted in the premises is valid search as contemplated under section 132 of the ITR. Then, my lords, what the tribunal did, tribunal again remanded to the tribunal to see whether the department has got the search warrant in the name of the SSC. And the tribunal, lordship will see the appeal annexer 3 to the appeal memo of 1172011, page 22. There, the tribunal, para 3, lordship will kindly see, they said that.
para 5.
Yes, para 5, my lords.
It is
Sorry.
found that the contention
Yes.
that there is no search warrant
Yes, in the lie.
is correct.
Yes. It is found that the contention of the SSC, there was no warrant of search issued in the name of the SSC to conduct the search is correct. Hence, no proceeding under section 153A could be initiated against the SSC. If find suitable to the department, they have to proceed with the SSC under section 153C. Coincidence, there was no proceeding after the judgment of the High Court and also of the tribunal matters.
Yeah.
Now, this order has happened. So, my lords, the law is clear. If there is no search, and your lordship have held in Kabul Chawla, Mita Gudgutia, there are so many judgments on the face of it that without, because 153A speaks that search conducted under section 132.
That's a trigger.
Yes, that is the triggering point.
Lordship, that is a slight correction. In the search was conducted on 9/8/2005 at the premises of the director or president of the institution and the registered office of the Shiksha Anushthan.
Without a warrant, sir.
No, it warrant was in the name of the president, the
No.
founder.
No,
Where do you get that? Where do you get that there is a warrant? Where do you get that? The finding is that there is no warrant.
para 3, Lordship may kindly see page 23 of the tribunal order.
No, para 5, sir.
Yes, para 5. And the society and the secretary, they are all separate assessees. They are all separate assessee.
Anyway,
That-
where is the warrant in the name of the society?
Yes.
In the assessment order, in the assessment order, a search and seizure operation was conducted on 9825 at the office premises of the society, Shiksha Anushthan, and the residential premises of the president directors.
Sir, please follow the question I'm asking you. Where is the search warrant?
And during the course of such operation,
Mr. Chimanka,
yes,
kindly listen carefully. Where is the search warrant?
You could not file it before the tribunal also. Though specifically asked by the tribunal to file. You took time but could not file.
Or can produce in the next.
So what about this? This takes care of how many appeals?
Beg your pardon, my
117, 118,
They
119.
relate to the different assessment years. The 117 relates to the assessment year 2-3. Then 118 relates to the assessment year
2001 to
1-2.
2000, 2001, 120 is for 2005 and 6, 121 is for 2004 and 5, 122 of 2011 is for assessment year 2006 and 7, 123 for the assessment year 2003 and 4.
Yes.
No, so the earliest 2001 up to
2006, 7.
6, 7.
Yes.
So this is from 117 onwards.
117 to 123.
Yes.
What about that first one, 37 of 2018?
32 and 33.
Yeah, we are not
It is
happy.
similar to your lordship 32, 33, 34, 17 and 37 are similar matter, and one matter is still pending, IT 31 of 2015. It may be tag up with that and maybe take
No, for different assessment
for
years.
different assessment.
Which are those assessment years?
These are for 32 is for assessment year 7, 8, 33 is for assessment year
Sorry.
33 is for 8, 9, 34 is for 9, 10, 17 of 2015 is for the assessment year 2010, 11, and 37 of 2018 is for the assessment year 2012 and 13.
And 31?
And another 31 is for the assessment year 2011, 12, which has not been listed with this case.
All right. Now we'll take it on board.
Yes.
All right.
and similarly, WPC is also pending.
These my lords,
156 of 2013.
I may be pardoned, my lords. This 32, 33 and 34 and 17. These relate to not to this such.
No.
These are the things where, my lords, there is a concurrent finding that in favor of the assessee that the amount which was not spent was surplus. That was spent was the infrastructure of the, and therefore the tribunal as well as the first appellate held that yes, that is exempted under section 13(1) of the Income Tax Act.
All right.
That
So
is-
those are different questions.
These different questions.
What about the first one, 37 of 2018?
That is not appearing, I think.
37 of 2018. Let's see the question there.
It is a similar matter related to all this year. 32, 33,
37 is
Yeah, section 11. 37 of 2018 is also section 11.
Yes.
Exemption under section 11.
Yes, exemption on section 11.
All right. Now take down first ITA 117 to 12011. These appeals by the revenue are directed against these are separate orders of the ITAT, right? For each of the-
Yes. That search assessment, well, previously it was block assessment. Now after 2000, every 2003, I think, that every assessment year will be separately passed.
I see.
6 years plus 1 year. The year
No,
when
the
each
order
starts.
for these 6 years is common.
Yes,
against
6
the
years
common
is
order.
common. Yes,
Common order dated.
yes. 6 years is common by the tribunal order.
Right. Common order dated 23rd June 2011, passed by the Income Tax Appellate Tribunal. Cuttack bench, Cuttack bracket IT80. In IT bracket SS bracket A numbers 39 to 45 PK of 2000 for the assessment years bracket A wise bracket 2000-01 to 2006-07 paragraph. The question sought to be urged by the revenue in these appeals for consideration of this court is whether the ITAT was justified in holding that the proceedings initiated against the respondent SSC under section 153 capital A Income Tax Act 1961 bracket Act was without jurisdiction, inasmuch as there was no search warrant at all issued preceding the search conducted in the residential and office premises of the respondent. Question mark. Paragraph. This is not the first round of litigation concerning the respondent SSC for the aforementioned years. Full stop. In fact, it is the second round of litigation. Full stop. The background facts are that the respondent is a society registered under the Societies Registration Act 1860 and was created for charitable purpose for imparting technical education. Full stop. It has established several educational institutions in Bhubaneswar and has been conferred the status of university by the University Grants Commission. Full stop. Paragraph. Admittedly, on 9th and 10th August 2005, a search was undertaken by the department in the residential premises of the president of the society. It is stated that books of accounts documents were seized during the course of the search. Full stop. Paragraph. Pursuant to such search and seizure operation, proceedings under section 153 capital A of the Act were initiated against the respondent SSC. Full stop. A tax demand of rupees 1535.75.989 was raised for the aforementioned 7 AYs, that is 2000-01 to 2006-07. Paragraph. Challenging the assessment orders, the respondent SSC filed appeals with Commissioner of Income Tax bracket appeals bracket CIT bracket A, and thereafter, and full stop. After the appeals were dismissed by the CIT bracket A, the SSC went an appeal before the ITAT, where for the first time it raised an additional ground that since no search warrant had been served on the SSC, the proceedings initiated under section 153 capital A of the Act were without legal basis. Paragraph. The ITAT in the first round remitted the matters to the CIT bracket A to first decide the additional ground, namely whether in fact any search warrant was issued authorizing the search conducted in the premises. Full stop. Agreed by the aforementioned order of the ITAT, the SSC came before this court in appeal, which came to be decided by a division bench of this court in Siksha O. Anusandan versus Commissioner of Income Tax, Orissa, 2011, 336 ITR 112. This court noted that from the order of the ITAT, it was not clear whether the revenue had produced the relevant search records to verify whether in fact there was search warrant. So it was held that the matter should not have been remitted by the ITAT to the CIT bracket A for adjudication of the additional ground without undertaking this exercise. Full stop. As a result, the order of the ITAT was set aside by this court and the matter was remitted to it to be reheard. Full stop. In the operative portion of its order, this court made it clear, open quotation, that if the tribunal comes to the conclusion that there was no search warrant in the name of the appellant, as conducted by the appellant SSC, then it would be open to the department to make assessment in a manner other than section 153 capital A, if permissible under the law. Paragraph. Pursuant to the above order of this court, the ITAT was again seized of the matter and passed the impugned order, against which the revenue is on appeal before this court. Full stop. In the said impugned order, the ITAT came to the categorical conclusion, after examining the records produced by the revenue, that no such warrants had been in fact issued authorized in the premises of the respondent SSC. Stop. As a result, the ITAT concluded that the assessments against the respondent SSC under section 153 capital A of the Act were open quotation without jurisdiction and are liable to be quashed. Unquote. Paragraph. Before this court, Mr. Chimanka placed reliance on the judgments of the Punjab and Haryana High Court in Jai Bhagwan Om Prakash was the Director of Inspection, 1994, 8 ITR 424, and of the Madras High Court in I. Devarajan versus Tamil Nadu Farmers Service Cooperative Federation, 131 ITR 506 bracket Madras bracket. Having examined the said two decisions, the court finds that they arose in completely different fact situations and therefore are distinguishable. So, as far as the present cases are concerned, this court in the first round litigation accepted the legal position that without there being a valid search warrant authorizing the search in the premises of the SSC under section 132 of the Act, the question of initiating proceedings under section 153 capital A of the Act did not arise. Stop. The matter had been remanded to the ITAT only for determining this factual aspect of the existence of a valid search warrant paragraph. Before this court also, the revenue is not been able to demonstrate that there did exist in the records of the review a valid search warrant authorizing the searches that were conducted in the premises of the respondent SSC on 9th and 10th August 2005. Full stop. Dehors such a search warrant, validly issued to authorize the search, the question of proceeding to initiate, the question of initiating proceedings under section 153 capital A of the Act simply does not arise. It simply did not arise. Full stop. Since the issue has turned purely on facts, the court is unable to find any error having been committed by the ITAT, and concluding that the entire assessment proceedings under section 153 capital A of the Act against the respondent SSC was invalid. Paragraph. As a result, the court is unable to swear to frame the questions as urged by the review in these appeals. Full stop. No substantial question of law arises for consideration by this court. Full stop. These appeals are accordingly dismissed.
If emailers can Lordship may make it AFR, it will be better.
All right.
AFR.
Lordship, that one line may be added that of the High Court order, which was passed on 8/9/2010. It may be open to the department to make assessment in the
There's no need. That's already there. We are not disturbing that.
The time limit is also covered, went away, gone away. 153C,
All right.
read it 153B.
All right.
Period is 5 years. That is gone.
All right. In the remaining appeals, including you have to take on board
Yes.
31 of 2015. You do that as special order taken on board. These appeals by the review are directed against individual orders passed by the ITAT in the corresponding appeals of the revenue through the DCIT bracket exemption before the ITAT against the respondent SSC for the assessment years bracket A-wise 2007-08 till 2012-13. Full stop. A common question sought to be urged by the revenue in these appeals is whether the Commissioner of Income Tax Appeals, bracket CITA, as well as the ITAT, allowing the benefit of exemption under section 11 of the Income Tax Act 1961 bracket Act to the SSC, respondent SSC. Question mark. Full stop. For the various AYs in question, in the returns filed by the SSC, which were picked up for scrutiny by the assessing officer bracket AO, bracket, the SSC had purportedly shown excess of income over expenditure, which had been transferred to its capital account. Full stop. The respondent SSC, having been granted registration in 12AA of the Act, claimed exemption under section 11 of the Act on the basis that it was carrying on the charitable activity of imparting education. Full stop. While denying the said exemption, the AO came to the conclusion that the SSC had been charging substantial fees from the students with a view to making profit, and that the imparting of education was for commercial motive and for making payments to single quotes interested persons, unquote. Paragraph. The CIT bracket A reverse the AO.
Para 5 of the CIT appeals order matters at page 19. Tabular form, it has been given.
Which IT are you reading now?
I'm my lord, it is 32 of 2013, my lords.
All right.
32 of 2013.
Page 19.
My lords, it starts para 5, page 19, my lords. I have carefully
20, yeah,
considered.
page 20 top. Yes.
Yes, it is a tabular form.
Right.
The learned CIT appeal has given and
Yeah, the
Yes,
CIT
concluded.
came to the conclusion, following the decision of the Supreme Court of India in SRTM Tirupani Trust versus CIT 1998 230 ITR 636. That capital expenditure was also considered as an application of the profits of the entity, and that expenditure incurred on the creation of infrastructure and building was permissible expenditure under section 11 bracket 1 bracket small a. Full stop. Reference is also made to the decision of the Delhi High Court in St. Lawrence Educational Society versus CIT 2010 197 taxman 504 bracket Delhi, and the judgment of the Punjab and Haryana High Court in Pine Grove International Charitable Trust versus Union of India 2010 327 ITR 73 bracket B and H bracket full stop.
my lords may kindly see also page 22, para 5.3, where
Yeah.
Aditnar Education Institution.
Correct.
Yes, ma'am.
Reference is also made to the decision of the Supreme Court in Adityanar Educational Institution versus additional CIT 1997 224 ITR 310 bracket SC. Paragraph. In the impugned order, the ITAT is concurred with the CITA.
Please, we can't. 32. 32 tribunal order from the
And that the conclusion was based on the various decisions of the Supreme Court of India. Yeah. Which one? The new Noble Educational Society.
Yes.
This takes a different view, right? The recent judgment of the Supreme Court.
I'm giving copy. You know.
No, we have it.
That is prospective. Last line, my lords.
Oh, it says it's prospective, is it?
Yes, yes.
Oh, okay. Paragraph. At this stage, right. At this, Mr. Chimanka drew the attention of the court to the recent decision of the Supreme Court of India in New Noble Educational Society versus Chief Commissioner of Income Tax, 2022, SEC Online 1458, where a larger bench of 3 honorable judges of the Supreme Court has taken a different view from the one expressed in Aditya Educational Institution, Supra, Pine Grove International Charitable Trust, bracket Supra, and American Hotel and Lodging Association versus CBDT. (2008) 10 SEC 509 and Queen's Education Society versus CIT 2015 8 SEC 47, all of which have been relied upon by the ITAT in the instant cases. Paragraph. However, this court notes that in New Noble Educational Society, Supra, the Supreme Court in para 88 clarified that, open quotation, since the present judgment has departed from the previous rulings regarding the meaning of the term single quote solely, in order to avoid disruption and give time to institutions likely to be affected to make appropriate changes and adjustments, it would be in the larger interests of society that the present judgment operates hereafter. Full stop. As a result, it is hereby directed that the law declared in the present judgment shall operate prospectively. Full stop, unquote. Paragraph. In view of the above clarification of the Supreme Court, the revenue cannot take advantage of the changed legal position as a result of the decision in New Noble Educational Society, Supra. Paragraph. As a result, the court is meant to frame the questions urged by the revenue in these appeals. Full stop. The appeals are accordingly dismissed.
That's my humble prayer is it also be affirmed.
All right.
Now the judgment of the Supreme Court has come, so they will.
Correct.
Mr. Chimako will go on saying that it is covered by the Supreme Court. Now onwards he will win. Much obliged.
All right.
This admission item number 2.
2 and 3. Here the only question, the ITC which are dissolved in the ex parte order.
1 minute, Mr. There were some writ petitions you said, right?
Yes. WPC 6519 of 12 and 156 of 13. Maybe listed first day.
Mr. Saul.
Acha, we'll list it on Thursday. These are your writ petitions, is it?
Yes. It is not in the list. Yes, No. It is not. It is there.
It's not listed. He wants it to be listed.
Give the copies.
That will be listed on Thursday. All right. Tell us.
Item 2, sir.
2 and 3 is similar. Is party order of assessment. Only the issue is the ITC has been dissolved. After that, I have collected the VAT report. That is almost all has been paid. I am just now filing the additional affidavit. You will see only a calculation issues, nothing. There is no factual issues. You will also kindly see the additional affidavit. It was prepared in 2018. Inadvertently, I have not filed. You will also kindly have a glance. I am clarified. All this 90% has been cleared.
No, but then you'll have to show it back to an authority. An assessment order.
Correct, Milord. Ex parte assessment order. And Milord, the audit report says Milord, books of is perfect. Only Milord issues ITC disallowance. Milord, I am not responsible.
Let it go back to the assessing officer.
Yes, that is what is calculated and passed order. Both the Milord.
An additional affidavit has been filed by the petitioner, stating that most of the taxes that are said to be due have already been paid.
First item,
By the-
90%, second item, 70%.
Has been paid by the sellers.
Seller, my lord.
Have been
Your
paid by the
Lordship,
sellers.
As you-
In other words, the SSC has sought to justify the claiming of input tax credit. Paragraph. Admittedly, these details were not available to the assessing officer who finalized the assessment by the impugned orders, which have been challenged in these two writ petitions. Full stop. In the circumstances, the court considers it appropriate, while setting aside the impugned assessment orders, to remand the matter to the assessing officer for a fresh examination
Verifying the VAT is, my lord.
of the details now produced by the documents now produced by the SSC,
Vis-a-vis VAT.
and pass a fresh order of assessment. Full stop. The matters will now be listed before the
AO.
state tax officer, is it?
AO, my lord, assessing authority, my lord,
That's
under the
right.
VAT Act.
No, who is the state tax officer? Is it?
Your Lordship, that Assistant Commissioner of State Tax.
Okay. All right. Before the assessing authority,
Yes.
concerned assessing authority in the Kendrapada circle, where the matters will be listed for directions on 20th February 2025.
Much.
20. Yeah, both cases. The writ petitions are accordingly disposed.
Much obliged.
Right.
Put both together.
Item number 4.
Wait, please, my lord. My lord, item 4, 5, and 6. I'm so sorry, my lord.
Yes.
I'm so sorry, my lord. Item 4, 5, and 6, my lord, are similar writ petitions, but may I request your lordships to take 6, my lord, as the lead
All right.
petition?
Sanjay Singhal.
Yes, my lord. My lord, here, my lord, these individuals, my lord, Sanjay Singhal was the former chairman and managing director of a company which went into CIRP process under the IBC. My lord, here a show cause notice is issued to these petitioners for a pre-CIRP period, where, my lord, for another pre-CIRP period, and another writ is already pending before your lordships have issued notice.
I see.
Well, I'll point that out. But here, my lord, the peculiar situation is this, that this particular show cause notice is in relation to as well as a period where, my lord, the IRP had taken over the company. The board of directors stood divested of all their powers under section 17 of the IBC. They were not in possession. They were not handling the company's records. And the peculiar issue is that the show cause notice invokes a provision 122(1)(a), which came in only in 2021. And here the period is 2017 to 2020. In fact,
Ex post facto, you say.
and penalty provision. And, my lord, apart from that, as far as the main liability is concerned, that is of the company. Pre-CIRP, your lordships have said, my lord, following Ghanshyam Mishra and SR Steel, there can be no liability. It has to be subject to the resolution plan. Resolution plan stands approved. During the CIRP period, my lord, I have nothing to do with this. There are allegations to say that I was coming there, etc. But I am not in possession of this company. In fact, the resolution professional is examined. He, my lord, says that I am not aware. There are statements of other, my lord, professionals of the company which say rating under the directions of the IRP. Despite that, my lord, what happens is that the IRP is not even made a notice in this case. A premeditated notice invoking section 122(1)(a), which comes in a year later, after the period involved, is, my lord, issued against me. I don't have the records, and this is a notice for abatement. My lord, if the main notice against the main company can't survive because of the IBC proceeding, the question of me defending an abatement notice wouldn't arise at all. And, my lord, section 74, regulation 74, which in terms, my lord, uses this legal principle to say that if for some reason the main notice cannot be proceeded with or it is, my lord, dropped, then notices against all the other co-notices will ipso facto, my lord, stand concluded.
But the only thing is now it's a stage of show cause notice.
Correct. But, my lord, this is completely without 122. May I just show, my lord, to your lordships, the notification by which this section comes in? That is at page 164, my lord. Annexure 4, my lord. If January to 21 by this notification of this section, my lord. Section itself, my lord, has been brought in at page 163 for your lordship sees the Finance Act. 1A.
Oh,
And the entire period that we are concerned with, my lord, which relates to clandestine removal, is July 17 to March 18.
so with effect from 1/1/21.
1/1/21. And this period, my lord, which they are calling us, my lord, calling upon us for abatement is only July 17 to March 18.
No. So the only question is,
How can, my lord, I answer this? My lord, this is completely without jurisdiction. And, my lord, what abatement can, my lord, I answer in a situation like this where, my lord, part of it is pre-CIRP and post that the IRP is in possession?
no, but what's the prejudice that's going to be caused?
My lord,
Suppose
the
you
prejudice is-
reply to the show cause notice.
My lord, I can't. My difficulty is I can't because, my lord, I am not even in possession of the books. I have nothing to do with this company during this period. And, my lord, I am being called upon to answer abatement. How can I answer abatement with, I have no records. I have, my lord, this is totally without jurisdiction.
No, but you'll say all this you're telling us in reply.
My lord, but there is no jurisdiction to
No,
invoke
that's
this.
true.
Kindly see, my lord, and, my lord, this is on the basis of a wrong jurisdictional fact. The show cause against me proceeds on the basis that I am the managing director and chairman of the company, whereas, my lord, the takeover of the company by the IRP is on 27/7/2017. Kindly see page 124, my lord. It starts with this assumption. That the Supreme Court in Raza Textile says that if you decide a jurisdictional fact erroneously and seize jurisdiction, then a writ will lie. And I can't be asked to participate in those proceedings. Well, Lord, kindly see page 124. This is the allegation against me. During the material period, my lord, para 9.2 at page 124.
Yes.
The first line, my lord, at para 9.2. During the material period, Shri Sanjay Singhal was the chairman and managing director of the company. I'm not. Kindly see page 180. Page 180 is the IRP's letter to me when he takes over the company on 27 July 2017.
Yes.
My lord, para 5, kindly see that in terms of section 17 of the IBC, the management of the affairs of the corporate debtor, Bhushan Steel and Bhushan Power and Steel, vests with the undersigned IRP. All the powers of the board of directors of the corporate debtor stand superseded and shall be exercised by the undersigned here. Henceforth, IRP will be authorized person of the corporate debtor, and the financial institutions which maintain accounts of the corporate debtor shall act on instruction of the IRP in relation to such accounts, and all officers and managers of the corporate debtor shall report to the IRP and provide access to such documents and
But
records
tell
of the
us one
corporate
thing.
debtor.
So this impugned show
Now-
cause note 8th February 2022,
That's right, my lord.
and you were to reply, I'm sure, within 30 days. Or
My lord, we haven't because we filed the rate. My lord, unfortunately, on the last occasion, my lord, your lordship noted that I was, my lord, in some personal difficulty.
No, that's true. I'm just saying you've come before this court in December 2022 vis-a-vis a show cause notice which issued to you in February.
My lord, I think the writ petition was filed earlier. It wasn't listed, my lord.
No. It was filed in July. Anyway,
July.
much beyond the date by which you
July, my lord. Now, my lord, I just wanted to point out one thing, my lord. In Ghanshyam Mishra, my lord, the Supreme Court has considered my lord, an order of the Allahabad High Court, where, my lord, for the CIRP period, my lord, was sent back on alternative remedy. And the Supreme Court says, my lord, that in these kind of matters, where the CIRP process has attained a finality, the resolution plan has been approved, then alternative remedy should never come in the way.
Is you can urge all these points.
But this is totally without jurisdiction, and that's
Correct,
why, my lord, kindly see this, my lord. Just, my lord, I won't trouble your lordships, my lord, more. My lord, may I just request your lordships to take this compilation, and for a pre-CIRP periods, my lord, your lordships have already.
Entertaining is one thing.
My lord, it's there. It's there.
Entertaining.
Kindly see your lordship's order, my lord. It's pending before your lordships.
I know, we've seen this is issuing notice. And
Yes, my lord, page 21
That's
of this compilation. And my lord, now kindly see just
to be filed. That's neither here nor there. That's
my lord, kindly just have a few pages of Ghanshyam Mishra, my lord.
order.
My lord, this judgment starts at page 171.
Correct.
Your lordships, in fact, considered it in your lordship's judgment. My lord, I've got that also.
Para 131 or something.
Yes, my lord.
Yeah.
Now, para 134 at page 239, my lord.
Correct.
This is, my lord, where the High Court of Allahabad, my lord, dismissed a petition on alternative remedy. Kindly see, my lord, after recording the prayers, para 135 at page 240. The High Court found that the appellant has an alternative efficacious remedy of filing a second appeal, as such deemed fit not to entertain the said petition. The basic grievance of the appellant in the writ petition was that after the resolution application was approved by the adjudicating authority and the management of the corporate debtor was transferred to the resolution applicant, all claims stood extinguished and the proceedings in respect thereof could not continue. The main ground raised on behalf of the respondent is with regard to the availability of the alternate remedy. The second ground raised is on the since the transfer date is prior to 2009 amendment, my lord, that of course the court finds that the amendment is clarificatory in nature. Para 138. In the foregoing paragraphs, we have held that that the 219 amendment to section 31 of the IBC is clarificatory and declaratory in nature, and therefore it will have a retrospective operation. As such, when the resolution plan is approved by the NCLT, the claims which are not part of the resolution plan shall stand extinguished and the proceedings related thereto shall stand terminated. Since the subject matter of the petition are the proceedings which relate to claims of the respondents prior to the approval plan, in the light of the view taken by us, the same cannot be continued. Equally, the claims which are not part of the resolution plan shall stand extinguished. In this view of the matter, we find that relegating the appellant to the alternative remedy would serve no purpose. A party cannot be made to run from one forum to another forum.
One forum to another forum.
Yes,
is a very different context.
Now the question is this, my lord, that here today, my lord, I am in a situation where These are all pre-CIRP dues, my lord. 1718 is the demand, and I'm being, my lord, show cause for abatement. My lord, kindly see section 122(1)(a), which is not even on the statute book. My lord, how does the authority, my lord, issue a notice to me to answer that? And in this situation where, my lord, it is completely without jurisdiction on the basis that I'm a managing director and chairman of the company, which I am not.
Right.
Then, my lord, how does, my lord, then Raza Textiles says so. Chief says Raza Textiles several times, my lord.
Yes.
Raza Textiles says, my lord, Supreme Court says that if you seize jurisdiction on the basis of an erroneous jurisdictional fact,
Yes.
then a writ will lie.
No, there's no question. I mean, writs lie in for various.
My lord, of course, it's,
Yes.
my lord, your lordship's discretion ultimately, but my lord, in these kind of situations where, my lord, this will cause, my lord, grave prejudice to me. I am not in possession of the company, my lord, during this period. How am I to answer this show cause notice?
Yes.
If, my lord, it is not liable to be issued to me.
What we can, so two situations. One is they've obviously not passed an adjudication order.
No,
You know
not
that.
yet, my lord.
So we make it time bound. Although
Lord,
the time for filing a reply is crossed, we give you another.
May I
30
request
days
for
or
one, my lord,
45
one
days.
indulgence, my lord, if your lordships, my lord, deem it proper. My lord, these are jurisdictional questions. My lord,
We
I'm
say that
let him decide the preliminary jurisdictional questions.
necessary. I mean, we not like a CPC thing where preliminary.
My lord, because this is ultimately, my lord, if the section
they deal
itself
with
is
all
not.
your points. They deal with all
My
the
lord,
points.
the problem is that these liabilities are huge. The moment.
All right.
My lord, the liabilities are huge, and these are individuals ultimately who were, my lord, either the managing director or the other two petitions are but former directors, my lord. And my lord, today, my lord, the other problem is this, that, my lord, 3 people have made statements that the IRP was giving directions during this period. IRP, my lord, disclaims responsibility to say, I didn't know. 3 other statements are there. He is not even noticed, my lord. Today, my lord, therefore, the notice assumes that the other statements which point a finger at me are correct and the IRP has nothing to do with it.
But
He has not even made a co-notice.
Show cause notice stage.
He is not even a co-notice. Therefore, they have, my lord, already taken a call that it is me who has to answer this.
Yeah, in the adjudication proceedings, if you want to make a request that somebody should be summoned, it's up to you to make those requests and for them to consider it.
My lord, the only problem is that today, my lord, we are dealing with a situation where I am being called upon to answer a notice on a provision which is not even in existence. My lord, kind of, my lord, your lordship knows, my lord, the lordship's experience shows, my lord, that many of these, my lord, will be confirmed just for the asking, my lord. And kindly see the kind of prejudice that will be caused in a situation like this, where neither I have the records of the company, nor I am in possession. The new resolution applicant has taken over the company.
Right.
I have nothing with me.
Right.
So how do I, my lord, that is why, my lord, if the jurisdictional question, my lord, your lordships were to enter in, at least, my lord, on this threshold, I will not be asked to go through this process where I can't really defend myself.
You see, these 3 writ petitions have been filed challenging a show cause notice dated 8th February 2022, issued by the Director General of what's GI stand? You see, Directorate General of Goods and Service Tax Intelligence. Calling upon the petitioner to reply to the allegations in the show cause notice within 30 days of the service of the notice. Paragraph. The impugned show cause notice has been issued invoking inter alia
Section 122, 1A, my lord.
Yeah.
1 capital A.
Section 122. Bracket 1 capital A of the Central Services Tax Act 2017 bracket CGST Act, which provides for penalties paragraph. The notices have been issued to these petitioners on the basis that they were associated in various capacities, either as single quotes outgoing chairman and managing director, unquote, or single quotes outgoing director, unquote, or single quotes director of Bhushan Power and Steel Limited, bracket BPSL, bracket. And for transactions related to period.
My lord, it's July 2017 to March 2018, with which what I am concerned, my lord.
Right. July 2017 to March 2018. That is a period prior to the coming into force of the aforementioned provision of the CGST Act. Paragraph. The show cause notice, issued on 8 February 2022 was required to be replied within 30 days of the receipt of the notice. Stop. The present writ petitions were sometime in July 2022 and were listed first for hearing before this court on 7th December 2022, when at the request of counsel of the petitioners, it was listed for today. Full stop. Throughout this period, there has been no stay of the impugned show cause notices. Full stop. The court is nevertheless informed by Mr. Tarun Gulati, learned senior counsel appearing for the petitioners, that notwithstanding the petitioners not having replied to the date, the adjudication proceedings are yet to be concluded, have not taken place yet. Full stop. Paragraph. Mr. Gulati urged before the court that the entire proceedings initiated against the petitioners was without jurisdiction, as BPSL was itself before the National Company Law Tribunal, bracket NCLT, in proceedings initiated under the Insolvency Code 2016, bracket IBC, and a corporate insolvency resolution process, bracket CIRP, was initiated, and an insolvency resolution professional, bracket IRP, bracket appointed in respect of the said BPSL, which ended in approval of a
On 5/9/2019.
insolvency resolution plan on 5th January 2019.
5th September.
5th September 2019. Full stop. Relying on the decision of the Supreme Court of India and Ghanshyam Mishra versus Edelweiss Asset Reconstruction Company Limited, 2021 9 SCC 657, Mr. Gulati urges that none of the present petitioners could be made liable for the dues of BPSL for a period prior to the by the aforementioned resolution plan, as has been settled by this court following the decision Ghanshyam Mishra Supra in Ferroalloys Corporation Limited, the state of Orissa. AR 2022, Orissa 17. There's also some Sri Metallics. Anyway, there's lots of decisions. We've given a lot of decisions. Full stop. Correct. As regards the availability of an alternative remedy, and no, as regards the issue of the court entertaining the present petition at the stage of the SCN, Mr. Gulati relies on the decision of the Supreme Court of India in Raza Textiles Limited versus Income Tax Officer Rampur, 1973 1 SEC 633, and certain observations of the Supreme Court
In para 3, my lord.
in Ghanshyam Mishra Supra itself. Paragraph. Having considered the above submissions, the court is of the view that since the adjudication proceedings are yet to commence, the better course would be to permit the petitioner to raise all the pleas that it has urged in the present writ petitions for in SCN that's been challenged in these writ petitions, and for the adjudication proceedings to be concluded in a time-bound manner. Full stop. The court also does not consider it appropriate, therefore, to express any view on any of the contentions raised in the present writ petition, in the petitions at the present stage. Full stop. Accordingly, the following directions are issued. 1. The petitioners, each of the petitioners will file the replies into the SCNs positively on or before 1st March. That gives you 2 months.
2 months.
1st March 2023. 2. The petitioners are permitted to urge all the pleas available to them in law, including the ones urged in the present petitions in reply to the SCNs. 3. The adjudicating authority will take into account all such pleas and deal with them in the adjudication of the past after giving the petitioners a hearing and considering the requests, if any, as regards summoning persons or documents in accordance with law. 3. The court clarifies that it has not expressed any view in the matter. Stop. It is needless to state that if the petitioners are aggrieved by the adjudication or order, it will be open to them to seek appropriate remedies in accordance with law. The petitions are disposed of the above actions.
In all the 3 cases, Lord, I am appearing for 2 and 4, Lord.
All right.
I'm for the position of 3.
All right.
Oblige, my lord. Item number 7.
May I please, my lord? The only prayer of the petitioner, my lord, is first appeal is rejected for non-submission of a certified copy, my lord. So now the assessment order already available, certified copy already available. So only one chance may be allowed. And similar issue already, there is a judgment of this honorable court already granted another chance for submission of the.
All right. Shows that.
Atlas.
Yeah. The only point urged in these 2 writ petitions is the denial of the petitioner to cure the defects in the form GST APL 02 submitted by it
Subsequent to that also.
within the last date provided for that purpose. Full stop. paragraph. The issue appears to be covered by the decision of this court dated 29 June 2022 in Petition Civil 14163 of 2022. Bracket Messrs. Atlas PVC Pipes Limited versus State of Orissa. Bracket. Accordingly, the petitions are disposed of with the direction that the impugned orders passed by the Joint Commission of order is not passed.
Rejected, my lord. This is a rejection for summarily rejection.
No.
Annex to 1.
Annex 1. Okay.
Yes, ma'am.
That the impugned orders is summarily rejecting the appeal filed by the petitioners in form GST APL 02 are hereby set aside. And the said corresponding appeals are restored to the file of the Joint Commission of State Tax bracket appeal CT and GST territorial range Cuttack 1 Cuttack. To stop the petition said authority on or before 20th February 2023 along with the certified copy of this order and produce the relevant certified copy of the order passed by the CT and GST officer. Full stop. Thereafter, the said appellate authority shall proceed to decide the appeal on merits and dispose it off by reasoned order in accordance with it. Full stop. The court clarifies that it is not the petitions are disposed of.
Your appellate authority is territorial bench, Jajpur Road.
My lord.
Okay. Territorial, not Cuttack. Territorial.
Territorial bench, Jajpur.
Territorial range, Jajpur, not Cuttack. Yeah, Jajpur Road.
Both read petition, my lord.
Item number 8.
Item 8, I may pray this matter may be taken up next week because one of the T. Chatterjee from outside, he will appear before your lordship. Any fixed date, maybe fixed below.
Let's see what the prayer is. Joint Commissioner and Commissioner, the orders must be appealable, no?
Yes, my lord. The second appeal, it is as per the section 112, second appeal is to be lie. But this since the tribunal is
So
not
we're passing standard orders. You see, since
the same order, your lordship may pass on the next date because yes,
right, when you were there, what
your lordship.
we're passing an order.
I'll-
You've paid 10%.
My lord,
How much tax has been paid?
my lord, the order is passed. That order is fine, but same order may be passed by the next year senior
No,
councillor.
sir, please
I'll
tell
be
us, have you
misunderstood.
paid 10% or you not paid anything? Have you paid any tax or you not paid any tax?
At the time of appeal, first appeal,
You must have paid some 10%, no?
10% tax you have paid. That was entertained. Your
Yes,
first appeal was entertained.
First appeal was entertained. The impugned order is under Annexure 7. It is passed, and thereafter this.
So the standard order that we're passing is that if you pay 20% of the remaining demanded tax, further course of proceedings will be stayed.
I only pray your lordship may pass the same order. Passed and same order may be passed on the next date. My lord. Next week, your lordship may fix any date so that I'll count.
Where is this person?
My lord, he is from Calcutta, my lord.
Just ask him to switch on his camera. He's got a laptop or he doesn't have a laptop?
My lord, I'll ask.
Just ask him that 2
Let it be
o'clock, we'll
passed
take it up at 2 o'clock. Ask him to just switch on his laptop and we'll pass the order now.
Let it be passed over.
Today.
Item number 9.
Item number 9 and 10, my lords,
Hmm.
are relating to the payment of the SBTRL 3, my lords. Your lordships have already passed orders. I just made the necessary correction marking the period. This 35922 is item number 9, my lords.
Right, right.
And I've just made I'm sorry to make.
Okay,
I've mentioned the amount and the period, my lords.
right.
And the relevant SBL DRS Form 3 is at page 72 and 74 in the first writ petition, my lords.
Right.
If you're,
So here we'll change the date to
whatever your lordship desires.
1st March, I think, 1st March 23.
1st March.
Ah.
And second page, your lordship, instead of Form 3, it will be Form 4, my lords. Discharge certificate in Form 4.
Yes. Form
And
4.
this by way of attachment has to be struck out. my lords.
Right, right. All right.
And there's small little direction, instead of shall, it be could, subject to your lordship's
Okay. All right. All right. Same.
The second matter is 35924. I've also made the necessary corrections.
All right.
And both will be by 1st of March.
1st of March.
2023.
Correct.
And the second part will be for
Form 4.
Form 4, and this by way of attachment to be struck.
Correct.
Greatly obliged.
All right.
9-10.
All right.
I am appearing for all the opposite parties.
All right.
Item number 11.
After there, your lordship, this matter is not pressed.
Okay. Dismissed is not pressed. All right.
Item 12.
None appears dismissed.
Item number 13.
None appears dismissed.
Item number 14.
Your Lordship, both item 14 and 15, I'll remove the defects and same may be listed.
All right. Last opportunity to remove the defects within a week. List thereafter. All right.
Obliged to Lordship.
Item number 16.
Item 16, I pray for 2 weeks' time. I will raise some additional question of law in this matter.
All right. At the request of counsel, the appellant. List on. February 9th.
Obliged.
Item 17.
Your Lordship, may I please, Your Lordship? Your Lordship, may kindly turn to page 23, the question of law. That is the penalty under section 42(5) of the Odisha Evaluated Tax, Odisha OVAT Act, Your Lordship. Your Lordship has already decided that case in the Chantilal case. Your Lordship, that is covered, Your Lordship. Page 23, whether on the facts and circumstances of the case, the tribunal is
42(5), correct.
Your Lordship.
So notice has to go.
Your Lordship.
Notice returnable. First May. All right.
Item number 18.
Item 18, Your Lordship, the copy of revision petition has not been sought to me, Your Lordship.
I have already served the copy, my lord.
No, Your Lordship, please.
The government. This is the order of assessment, pre-amendment 1 for 2012 to 12/5/2015.
I have to go through the record. I have not seen, Your Lordship.
This was, I have already kept it.
5D
I have
defect is there.
already sent. This is in the file also.
No, but he has to get a copy. All right. Copy of the petition be served on Mr. Mishra today itself. We'll call it next Monday then. 9 January.
Item 19.
This is 1 and 2 to be dispensed with. And another defect is that that is prayer of the petitioner, because it is a STRV, so we are framing the question of law. So we are not considering prayer. So apart from that, my Lord Justice Raman is concerned in this matter. So
Oh, I see. List before a bench of which Justice Raman is not a member. On any date it can be. On 11 January 23. Defects be cured in the meanwhile.
that prayer that to be ignored, my Lord. That defect number 9 and 1 and 2 is dispensed with. Certified.
with these concerned, then we won't pass any orders. So, all right.
Item 20.
May I please your lordships? Your lordships, I'm appearing on behalf of Mr. BP Mansi. The lordships may kindly grant me 1 week time to rectify the
That's the
defect.
last chance. 1 week's time is granted for curing defects. List thereafter.
Obliged.
Item
Same order.
Item number 22.
May I please, your lordships? Your lordships, the question of law is at page 11, your lordships. Whether on the fact and in the circumstance of the case, the disallowance of input tax credit to petitioner on the purchase of engine oil, air conditioning machine at MS Angle is valid or sustainable in the eyes of law when all these commodities are directly used in the manufacturing process and coming under the definition of input under section 225 of the OVAT Act. And the second question is relevant, your lordships, whether on the facts and circumstances of the case in denying the benefit by ITC while the petitioner is having the documented evidences of tax paid to government treasury, and that is original tax invoices as required under OVAT Act, your lordships. Pursuant to that, also Arise India case is their your lordships judgment, which is confirmed by the Honorable Apex Court. And so far as the assessment order is concerned, your lordships kindly have a glance. At page
It's coming up for the first time.
Yes, your lordships.
Notice. Or it should be admitted.
Your lordship.
All right. Admit the following questions are framed for consideration. 1 and A and B. Page. No, I think penalty also, right?
Penalties.
Yeah.
Penalty is consequential. Whatever will be deleted.
Correct.
Yes.
A, B, and C. All right.
Obliged.
Twice.
Yeah, correct.
Your lordship, that has already been decided. It is 40 to 5, it is twice. Whatever deleted, if the quantum will be deleted, then consequential penalty will be that twice.
But it is prior to 2015.
All right.
Obliged.
A, B, and C. All right.
Obliged.
List for final hearing on 11th.
In the meantime, your lordships, no question action.
Then your lordship has to pay the
Where I
interest.
think it was not taking this come up for the first time after 2 years. And obviously, there's no just issue notice on stay.
Obliged. Obliged.
Item number 23.
23, my lords, 1 week time may be granted
Or
to remove.
last option to remove defects within a week. Yes, thereafter.
Item 24.
My lord, in item 24, your lordship, the petitioner has amalgamated with the Mangalam Cement Limited, your lordships. The cost title requires amendment, your lordships. Let me share the amended copy of the cost title, your lordships.
But you have to file an application.
Yes,
Counsel, the petitioner seeks to file an application to amend the cost title. And its request list on February.
Obliged. My lord, this required to change to Andhra Justice Ramani in the before the tribunal, my lords.
Whatever, sir, you file an application. Right.
Item 25.
Your lordship, item 25, your lordship, the question of clause, page 25, your lordship. Your lordship, whether in the facts and circumstances of the case, the tribunal, so far as it is held to be technically to do not stand as a bar for claiming input tax credit on stock of goods claimed to have been available on 1/4/2005. The date of introduction of OVAT Act, even though the dealer assessee failed to adduce evidence in VAT 607 and VAT 608 or runs contradictory to the provision contained in section 107 reduced rule 1. Your lordship, for the first time it has been listed. Your lordship, notice to be go.
No, but is there concurrent findings or what?
Your lordship, tribunal's order, your lordship, may kindly turn.
First, the first appellate court. All right.
Page 52. It starts from page 50 at paragraph 9 of the tribunal's order. And tribunal is allowed at 52 it is entertained and when benefits are extended to and applying it analogically to present factual position, it can well be said technicality should not stand as a bar against the dealer assessee who is claiming for
This is a
ITC and
notice return. Okay. Notice returnable 4th May.
obliged.
Item number 26.
Please, ma'am.
May be taken up with item 60, my lords. It is with regard to RERA. So,
all right.
Yeah, in my case, actually, notice also has not been issued. It has to be issued to the LIC. LIC HFL Care Homes Limited. We are the association, my lords, under the LIC housing project. Similar issues in our case, my lords, where, my lords, we are challenging the fact that we are still in the category of sub-lessees, even though the RERA mandates that we have to be given good title. We are still in the, my lords, status of sub-lessees, and there are various impediments on our title. And also, my lord, the common areas, as your lordship is examining in the other case, that the common areas handed association. Here, my lords, the common areas are.
Why have you come directly here? Because you have a RERA tribunal, right?
We have a RERA tribunal.
No. Why can't you go there for all these issues that you have with the?
No, they are advertising also. Similar issues are there. Also advertising for a second year. Lordship may kindly turn to that advertisement 146.
No. It's a dispute you have with this LIC Care Homes Limited.
Yes, my lords. Issue is
you're saying ask them to form an association of allottees and all of that.
That also the fact that they are trying to page 147.
No, so why can't these prayers be made before a RERA tribunal? That's what I want to know.
what your lordship is saying that this particular dispute is adjudicable by the RERA authority. It should go and approach the RERA authority because the regular
understand.
court is
I had thought about it, but I thought that since your lordship is already examining the.
No, they're examining a larger question of resolving the legal problem in the act.
My lords.
That's how they've now.
No, the legal problem here.
They drafted a bill and it's now being. I don't know. We'll get to know when we take up the other matter. But this issue that association of allottees and all that.
Possibly, my lord, the issue of title vis-a-vis section 17 under the promoter shall execute a registered conveyance deed in favor of the allottees along with the undivided proportionate title in the common areas.
In favor of the association.
Yes, title. So now the title is not even there with the nature of the agreement is such, man. It's a public.
So once the new law comes in, there'll be greater clarity and it will be applied by the RERA itself.
I think
it is
this
actually
is a very good point.
It would be binding on all. Sorry,
this is a very good point to be all the RERA authority. What my learned friend is submitting. Can ask this before because
RERA authority may not. Just
everybody is bound. First of all, this opposite party number 4 will be bound by that new law.
My lords.
Once that law
goes without saying,
then it will all become streamlined. The association, the registration, and if they fail to do it, then go before the RERA.
Here the issue really would be whether they would really have the power to. It's a LIC has a formatted agreement.
No.
Formatted agreement
formats are all going to change. The appendices now to the new act,
my lords,
which they are proposing, will have all the formats, different formats.
Model cell date, everything we are
So your lordship may observe that I will ventilate my grievance before the RERA.
Yes.
My lords, at the earliest because now they are also LIC is also planning to withdraw withdraw the maintenance facilities.
All right.
And so we'll be left in a vacuum.
No, Mr. Palit, senior counsel for the petitioner, seeks leave to withdraw the present petition with liberty to approach the what is the exact wording of the tribunal?
That is RERA authority.
Real estate authority.
Orissa
Real Estate Regulatory Authority in the first instance with the prayer and thereafter seek appropriate remedies in accordance with law. The writ petition is disposed of with liberty spread.
Item number 27.
May it please your lordship. I am for
Correction,
the-
yeah. The office note has been perused. The correction be carried out as indicated. All right.
Item 28.
May it please your lordships.
What is defect number 6?
I'll remove the defect, my lord.
This order of the Tahsildar must be an appealable order.
My lord, they have already converted to Unnata Yojana Jogya, and thereafter we have leased out for this.
No, due procedure has not been followed. Your
That you can agitate before the appellate forum if there is no if the due procedure.
It is confirmed by the collector. This order is appealable before the collector. What collector has confirmed it?
No, but why are you coming confirmed by which? By sub-collector, you mean?
No, it is to the sub-collector, then sub-collector recommended to the collector and collector confirmed it.
But in any case, it cannot be PIL then. You have to challenge.
No, 1 minute. When did he confirm it?
Confirmed, my lord, in 2022, your lordships.
Where have we said that? That order you are not challenging?
That here, my lord, it is challenged, my lord.
No.
Yes,
See your prayer clause. There's no 2022 order at all.
No, my lord, the collector has confirmed it on 16 to 2022. My lord.
Where do you get that?
Annexure?
Annexure, this is the order, my lord. But it is 124, your lordship will find. 8/7/2021. Sorry, my lord.
Why have you come so late?
But it was not known to the petitioners, your lordship. Your lordship may kindly see for a 131, your lordship may 134. For a moment, my lord, the notice. The notice, my lord, it is served upon Ganeshwar Pradhan, who has, my lord, expired in the year 92. These are manufactured.
My lord,
and in the pendant period, my lord, this has been done whenever, my lord, there is serious shutdown and lockdown. Nobody is outside, my lord, in the from the house. Lordship may kindly see 134 page. Ganeshwar Pradhan has received the notice. They have said, I have, my lord, annexed that death certificate of Ganeshwar Pradhan, who is dead in the with effect, my lord, 10/8/1992. But it is stated that notice has been served upon him. So everything has been manufactured. What statement, my lord?
My lord, may I submit one thing to my lordship? This annexure which he is showing, that is not the conversion order. That is not the alienation. In 2021, collector leased out the land to IDCO. The original order, which by virtue of which the land was converted to Unnat Yoga Anavati, that is at page 68. He is not showing that. Annexure 9, page 68.
No, 71. 71, 18/12/2020, my lord.
No. 2016. This is collector's order.
71,
Annexure 9.
18/12/2020, my lord, I have challenged this.
No, when you woke up one fine day, that's the whole problem.
In 2016.
It is not known to anybody else. No
For
public
last
notice
6
has been
years,
made.
it is already converted.
My lord, no public notice has
That's
been
all.
made.
We're not.
That anybody can say.
But no public notice has been made, my lord. It is mandated under Rule 34E of the OLR Act.
Regarding conversion of the land in question to Anabad, is it?
No,
Earlier, my lord, it was Gochara.
Unnata Yogya Anab. Unnata Yogya Anavadi.
No, it is not Unnata Yogya Anavadi, my lord. The case of the petitioner is like this. It is earlier, my lord, Gochara land. I have annexed that.
Yes.
That is converted to, my lord, UJJ. Unnata Yojana.
Yogya. I'm sorry.
It is not leasable at all. You lordship may kindly see
Land
page
is reserved
71.
for developmental purpose.
It is not at all leasable, your lordship. Law says it is not leasable. My lordship, kindly see page 71. As the applied land or from UJJ number,
this is important.
it is not leasable at all, your lordship.
2016, the conversion was made. By the
Earlier, my lord, the writ
that is
application was filed.
Annexure 9.
Earlier also the writ application was filed, though file was not reserved in my office, my lord.
No, you have to revive that writ petition. This is very convenient. So you 26997
You lordship
saying that your file is not traceable.
You lordship
Give you permission to revive that writ petition. Since that file is not traceable, you file a fresh writ petition.
You lordship, my lord. Subsequently, my lord, I have collected those papers, my lord. I have challenged it.
No. You say
Your Lordship may observe that I will give giving liberty, I may be permitted to withdraw to revive that writ application.
that we already gave you
It is
liberty
already
there.
given
There's
in
how many
that
times
order.
liberty to be given?
Your Lordship may observe that, my lord. Though
No.
liberty was given, my lord, I will revive that writ
The
application.
grievance of the present petitioners is about conversion of a plot of land in Moza Sardapur Tehsil Angu.
Your Lordship may simply say, my lord, I may be permitted to withdraw that, revive that writ application. Suffice my problem.
Which was earlier in Kisam Gochar to Kisam Unnat Jojana
Unnata
Jogya
Jojana Jogya, UJJ.
bracket UJJ bracket. And allotment and the consequential allotment of the said land in favor of IDCO, ITCO. Paragraph. The orders on the basis of which such conversion was permitted is dated, is an order passed by the collector Angul on 20th August 2016. Full stop. Earlier, the petitioners had filed writ petition civil PIL number 26997 of 2017, which came to be dismissed for non-prosecution when the court was informed that by counsel for the petitioners in that case that the file was not traceable. Stop liberty was granted by the court while dismissing that writ petition to revive it as and when the papers were traced. Full stop. Paragraph. Without reviving that writ petition, the present fresh writ petition has been filed. Full stop. As far as the main grievance is concerned, the conversion already having taken place more than 6 years ago, the court does not at this stage the court is not at this stage inclined to interfere with the status quo prevailing since then. Full stop. The objections of the petitioners were considered and orders were passed both by the Tahsildar and sub-collector, rejecting the pleas of the petitioner. And these orders were passed in 2020 itself. Stop. The court made it therefore to interfere in the matter, and the petition is accordingly dismissed.
One prayer, your lordship. But that is of the year 2017. That is from Gochoro to my lord UJJ. I had challenged it. Here, my lord, that is UJJ to my lord Patito, and it is allotment to the IDCO. That
That's
I have
right.
read here.
Yeah, we've said
So
that.
it is my lord here that writ application relates to my lord the year 2017.
Okay, let it all come to an end, sir. Otherwise,
And
we'll have
it
endless
is of the
litigation
year
on this.
2020, your lordships. I have challenged that order thereafter. After fresh cause of action comes.
All right. We're not inclined.
Item 29.
May I please, your lordship. My lord, the opposite party number 4, without a inquiry in the field, my lord, so approve some project for repairing, my lord, that is totally illegal, my lords, without any inquiry and without.
Your representation, where's the proof?
Yes, my lord. My representation, Annexure 3,
Where's
page 54,
where's
pending before the collector.
Where is the proof of delivery of the representation?
A postal. No, my lord, I have not.
You make a fresh, the petitioner seeking withdraw present petition with liberty to make a fresh representation to the collector, to the authorities. And after following up on such representation, to seek appropriate remedies in accordance with law. Dispose of his withdrawn liberty is paid for.
Item number 30. Item 30.
None, please dismiss. Not possible.
Item 31.
Your Lordship, item number 31, I'm very sorry, Your Lordship, beg your pardon. Lordship, for the last occasion has directed to take instructions. It is that online filing or offline filing of the appeal, Your Lordship. The acceptance so far. Your Lordship, my office has issued the letter for instruction, but wrong letter to the wrong officer. Your Lordship, a short date may be fixed. Only on that aspect, Your Lordship.
Things are so simple, Milord.
Yes, I am
No,
accepting.
section 107.
the other day, your lordship have already rendered the order, your lordship almost have passed the last occasion. If your lordship will see the last order passed.
Correct.
But section 107 says the appeal is to file either electronically or otherwise as notified by the commissioner. There is no notification by the government. Therefore, my lords, either it can be, your lordship, either it can be by electronic mode or even hard copy can be filed. And this view is also, my lords, rendered by Honorable Andhra Pradesh High Court, a copy of the judgment I have the other day. So that on that point only I wanted my friend to take instruction.
It is to be seen also whether
no factual instruction necessary.
No factual, your lordship.
And now they have accepted that appeal is filed. The last occasion, my lords have taken record along with the memo I have filed document. The office of the additional commissioner, they have accepted that this is and that acceptance is by way of issuing a memo in APL GST APL 2, which is an acknowledgement issued under Rule 1082 of the OGST rules. So now they have accepted. There is an appeal filed.
That is a mistake committed by the officer for the first time. You'll date in the state of Odisha. No offline filing, no manual filing has been accepted till date. It is the only case I have seen ever. Your lordship, this is a mistake. Your lordship, till date, commissioner has not issued any notification so far as the manual acceptance, your lordship. Your lordship, it is to be seen whether Andhra Pradesh Commission, because the statute itself says that commissioner has to issue the notification about your lordship in order to accepting the appeal manually, your lordship. Till date, no notification, because everything, your lordship, what happened, your lordship, the entire portal is controlled by the GSTN. So everything, each of the filing of the assessee, also each of the order passed by the authority are to be uploaded in the GSTN portal, your lordship. So unless it is shown in the portal, so your lordship, the officer, the authority is to pass, and that is to be uploaded in the portal. So both has to be shown in the only on that technical aspect. I have to take instruction. Your lordship, I am asking my clerk has issued the letter, your lordship, wrong authority. So I have to take instruction from the commissioner.
Need some more time for instructions. List on 9th February.
Oh, bless you.
Item 32.
Defects.
My lord. Here the petitioner.
Defects, sir.
Defects are there. So I may be permitted by next year.
Last option to remove the defects within a week, less thereafter.
Item 33.
May it please your lordships. This case is squarely covered by the judgment of this honorable court by my Lord Chief Justice in 8259 of 2019 that if any claim is not filed, it will what has happened here, my lords, against order of imposition of penalty and penalty, my lords, and tax. I filed a writ petition in the year 2016. There, my lords, I paid the tax. Lords, you will kindly see Annexure 9 series at page 266. I paid the tax and I got the vehicle released. Thereafter, my lords, during the pendency of the writ petition, that is, my lords, Annexure 10 at page 269, my lords, is to find that I brought to the notice of this honorable court about the corporate insolvency resolution process. And lords, you will kindly turn to page 278. Learned standing counsel appearing for the opposite party transport does not dispute the aforesaid position of law on which reliance has been placed by the learned counsel for the petitioner. However, he submitted that in the writ petition no such prayer was made. It is held that
it is true
that when the writ petitions were filed, the aforesaid fact was not in existence, but later on the proceeding having been initiated in the year 2017, the petitioner could have very well amended the writ petition, his prayer, that the claim of one of the financial creditor is subject to NCLT.
Anyway, we'll just issue notice.
Yes. And the Honorable Court.
All right. You say notice, you accept notice for?
Yes,
Transport Commissioner.
my lord.
Then for State of Orissa? All right, Mr. Ishwar Manti accepts notice.
I'll solve. Extra copy.
So he accepts for Mr. Bera for 1 and 2.
My lord, for the Transport Commissioner.
And the tax recovery officer?
Yes, my lord.
Yes.
I am.
1 and 2 and Mr. Manti for 3. Replies be filed within 8 weeks, rejoined with the next date. In the next date, no coercive steps be taken against the petitioner. List on. On 8th May. 8th May.
Item 30, covered by your lordship's judgment, that extended period of limitation in terms of Honorable Supreme Court order is binding on all authorities during COVID pandemic period. Assessment year 21-22, delay in filing of audit report. Assess is a society having 12 registration since 2005. Delay in filing of.
And the matter is appealable.
Why should he be sent?
And Annexure 6, my lord, kindly 6, Annexure 7.
It's this is a condonation delay petition.
And he is not cooperating. However, there is from the end, further cited under 3 above, a final opportunity was given requesting to furnish the information by 10/6/22, for which also there was no complaints from the end. No complaints has been made. Annexure 7, my lord.
My lord, I have already written my delay condonation petition that delay was attributable to pandemic. Lordship in page 26, your lordship, during the financial 1920, there was persistent disturbance in the institution on account of pandemic and financial crisis. Lordship, page 26, Annexure 6, I have filed. This is admittedly during the pandemic period only. The extended due date was February 15th of February. I filed on 29th March. If I'm not if this is not allowed, entire 11 exemptions will be disallowed. Because if the due date is so, the question of going to appeal doesn't if section 12(11) is not allowed to me.
In view of the above, it is concluded that you have not uploaded the ITR and there was no sufficient reason for such.
I have produced for your lordship that it was delayed, and I have produced, I have uploaded on 29th March 2021, much during the pandemic period. And your lordship's order is clearly covered. Para 3 and 4.
No, where does that show you upload on 29th March?
It's lordship
9th March or 29th March?
29th March. That is Annexure 3 and 4, page 18 and 19. Date of filing, e-filing, Form 10B, 29/3/2021. 7/22 is the timing given. And 19 is that ITR 7 was filed. Same 29 March 1952.
Annexure 5 order has been passed under section 143(1).
But without, I can file the rectification petition once the delay condonation is allowed. Because otherwise, irrespective of, I will not get the exemptions. Section 11 exemptions, if the 119(2)B is not allowed, I will be treated as a AOP, even if I file an appeal, Your Lordship.
Where is the order dismissing your appeal?
It's page 27, Your Lordship. 26 is my petition, where I have, during the financial year, page 26, there has been a persistent disturbance in management.
No,
and
that he just
day-to-day
now read, sir. He just now read that letter.
Lordship.
No, the order is at page
27, Your Lordship.
You see, it appears that the petitioner's application for continuation of delay in filing the statutory forms, public ITR, under section 119 bracket small 2 bracket small b of the Income Tax Act 1961 bracket Act for the assessment year 2020-21 was rejected by the CIT bracket exemption. On the ground that petitioner had not uploaded the required forms. Paragraph. In the application for continuation of delay filed by the petitioner, it has been explained that the institution remained closed for several months on account of the COVID pandemic. And there was therefore delay in having the audit conducted and return submitted in form 10 capital B. So, paragraph, having heard learned counsel of the parties, the court is of the view that the ground that on account of the pandemic, the requisite forms could not be filed appears to be a bona fide and genuine one and ought to have been accepted by the CIT bracket exemption. Paragraph. Consequently, the communication 2nd August 2022 rejecting the petitioner's prayer for continuation of delays hereby set aside. The delay in filing the requisite form shall now stand condoned. Full stop. The department will now proceed in accordance with law on the basis that the form has been filed in due time. The petition is disposed of later.
Item 35.
May I please, Your Lord? Your Lord, kindly recall Your Lordship was pleased to pass the interim order directing to lift the attachment after verifying the payments made.
Correct.
Your Lordship, I made an application. Your Lordship may kindly refer to the IA file. At Annexure 7, I have made an application requesting to verify the payment and following Your Lordship's direction to lift the attachment accordingly.
Why is the attachment not lifted?
Your Lordship, that application has been disposed of, Your Lordship. Your Lordship, what happened? The petitioner has
May I place, Your Lordship? I may be permitted. Your Lordship, after filing this interim application, yesterday I've been served with this rejection application, Your Lordship. Dealing with the request for lifting of attachment, Your Lordship may kindly see at the last page. There are thus to sum up, Your Lordship.
Yes.
The taxpayer paid amount of tax and interest amounting rupees 411,818 much after issuance of demand notice as well as issue of bank attachment in DRC 3. Payment in DRC 3 is made pursuant to voluntary compliance in respect of self-assessed tax. Besides, tax amount of 156,784 has not been paid. Has not paid the penalty of 31,680. Taxpayer has not paid due interest from the date of order to the date of payment made on 19/7/21, and taxpayer debited the electronic credit ledger on payment of tax of 156,784. Your Lordship, while dealing with this application, the opposite party number 1 has referred to Your Lordship's judgment at page 3. In the case of Jyoti Construction versus the Deputy Commissioner City GST, Your Lordship, where Your Lordship has held that while making payment of pre-deposit, when the amount is debited from the electronic credit ledger, it is permissible, Your Lordship. So far as it relates to this fact, Your Lordship, this judgment of Your Lordship is dated 7/10/21. After that, Your Lordship, Central Board of Indirect Taxes and Customs has issued a clarification
saying you can use it for pre-deposit.
Yes, Your Lordship. Page 5 of the Before reading this out, Your Lordship, I'll clarify one thing, Your Lordship. In the judgment delivered by Your Lordship, the order delivered by Your Lordship, the question was the pre-deposit for filing of appeal. So far as it relates to section 107(6)(b. Here, the case is, Your Lordship, adjudication was made. Pursuant to the adjudication, my bank account was attached. I voluntarily made payment under section 73(5) and I informed them, and they withdrew the attachment, taking note of the payment made. Subsequently, without any further notice, again my bank account was attached of the very same amount which was attached earlier, which was rupees 4,90,000. Admittedly, Your Lordship, opposite party number 1 says that I've paid rupees 4,11,000. So far as it relates to debiting 1,56,000 from the credit ledger, Your Lordship, is dealt with in the CBIC circular at page 5. Page 5, point number 6, Your Lordship.
Yes.
Whether the amount available in the electronic credit ledger can be used for making payment of any tax under GST laws, Your Lordship. The bold part, clause number 4 at the right-hand side. Accordingly, it is clarified that any payment towards output tax, whether self-assessed in the return or payable as a consequence of any proceeding instituted laws, can be made by utilization of the amount available in the credit ledger of a registered person, Your Lordship. Your Lordship, subsequently, Bombay High Court, while dealing with the similar issue, has permitted, again, the question was for payment of pre-deposit, but then dealing with this CBIC circular has permitted payment from the electronic credit ledger, Your Lordship. So far as it relates to this application.
What about the penalty amount?
Penalty amount, Your Lordship, is 31,000. I'll make the payment.
Oh.
Your Lordship, section 79(1)(c), under which this recovery is invoked. If Your Lordship may permit, I'll place the provision. 79(1)(c),
Yes.
Roman 1.
Yes.
Proper officer may, by a notice in writing, require any other person from whom money is due or may become due to such person or who holds or may subsequently hold money for or on account of such person to pay to the government either forthwith upon the money becoming due or being held, or within the time specified in the notice, not being before the money becomes due or is held, so much of the money as is sufficient to pay the amount due from such person, or the whole of the money when it is equal to or less than that amount. The last 4 lines are important, Your Lordship. Much of money as is sufficient to pay the amount. When there was an attachment earlier of rupees 4,98,000, I have already paid a sum of 4,11,000, Your Lordship. And the subsequent stand that interest has to be paid and the penalty, there can be an initiation of a separate proceeding, Your Lordship.
No, but now,
Your Lordship, so far as that judgment passed by Your Lordship is so far as that is pre-deposit. Also, Bombay High Court is also pre-deposit. Your Lordship, the statute section 41 subsection 2, Your Lordship, is very much clear. Your Lordship, is only so far as the self-assessed tax in the return is to be credited, is to be debited from the credit ledger, Your Lordship. And all other output tax or any demand is to be paid from the cash ledger, Your Lordship. So
the circular seems to permit.
So that circular, Your Lordship, that circular, I have to verify because I have already prepared the counter. Your Lordship, this case, originally, Your Lordship has issued notice and has been is pleased to fix on 9th, Your Lordship. So already my counter is ready on basing on that circular, Your Lordship. So I may be permitted to on that day, Your Lordship, it may be fixed on that day. So for us, all this clarification, I can my counter, Your Lordship.
Your Lordship, CBIC circular is there.
Your Lordship, whether CBIC circular is
learned
or
opposite
whether it is clarification.
Dealing with this application has neither referred to the circular nor any other judgment, only referred which is suitable, obviously,
Your Lordship, only
to the opposite party.
The statute is very clear.
You're bound by your own circular.
Your Lordship, only that circular, whether that circular is binding or not, Your Lordship, it is to be seen. Because, Your Lordship, that circular, I have to go to that circular and in my counter, Your Lordship has originally fixed this case on 9th January.
Or it is IA 1 of 2023 is a notice, Mr. Mishra accepts notice, 6 times for instructions. It is seen that in the meanwhile, an order has been passed on 31st December 2022 by the additional CT and GST officer, rejecting the prayer of the petitioner for lifting of the bank attachment. List on the date already fixed, 9 January.
If I may pray, your lordship, subject to payment of the penalty amount which they say, my attachment may be lifted.
Today 9th is not even.
Your lordship, the problem is that since your lordship has passed on 22nd December.
Why do you meanwhile pay the penalty?
Yes, your lordship.
Meanwhile, you can pay the penalty amount.
But attachment may be lifted. Let them file the counter. Your lordship may kindly see this circular is on record and they are seeking instruction.
This order has been set aside then.
Yes, your lordship.
This order will have to be set aside, but you have not challenged this order. You file an application to challenge it.
I will file an application, but so far as it relates to the
attachment.
attachment.
Is permitted to file an application to amend the writ petition to challenge the above order. Correct. List on 9th. On 9th, we can do all of it.
Obliged, your lordship.
Right.
Item 36.
Item 36. When similar matter is passed on, it is not offered. Passed in double piece number.
That is in portions of the format notice, they filed objection. Now they need an order that will be considered.
Same order as in 36.
Yesterday 36. Double piece number 35884 by 2022. Yesterday item 36.
All right.
Yesterday item number 36.
Today also 36. All right.
Item 37. Item number 37.
Please to your lordship, Appellant Miller, in this case Miller, the IA number 1605 of 2020, that miscase is filed by the respondent state, but copy is not served on me, Miller.
What's the matter about, sir?
The state has filed their miscase. I have not.
Kindly tell us what your appeal is about.
My application, Miller, the case is the writ application is dismissed on the question of the dismiss for default. On that dismiss for default order, I filed the writ appeal, Miller. On merit, it was not dismissed. That the default. So I restoration petition there. The restoration petition, though it was in a limitation, so it was the restoration petition was dismissed. So on that ground, I came before your lordship, Miller. So on merit, it was not listed. The batch of cases I am continuing from since 2003 till now. I am continuing Shiksha Sahayaka, then thereafter junior teacher. Batch of cases they are pending before the honorable single judge. But it was only for the question of dismiss for default. I came before your lordship, my lord. So my humble submission before your lordship.
Filed for restoration.
My lord, that is, your lordship may turn to, because that is the on limitation. I filed the restoration page 21 of the brief. Order dated 2012-2019, page 21. That is the order. Only question that
you didn't file requisites for 13 years. Sir.
Only because the earlier advocate, my lord.
13 years. Will anyone sleep over a matter for 13 years?
The case is 13, but the order, my question is that I am continuing till now, my lord. In service, my lord, I am continuing.
Yeah.
From today, I am continuing till now. Okay. I am getting the service, my lord, salary, my lord. Only the dismiss for default that I came before your lordship. But on merit, a batch of cases is pending before the honorable single judge for hearing. So I am one of them, my lord. So the similar situated persons are also filed, like me. Their cases is pending there for hearing on merit. It is only for dismiss for default. I came before your lordship. So if it will be not allowed, my lord, and my humble submission before your lordship, rematter for here on merit, my lord, because the other cases are pending, batch of cases, not on one case, my lord. Because I am continuing in 2003. I am continuing 20 years. I am continuing getting salary, my lord. There is no problem. Only some one order I came before the file the writ application. That was notice was issued, but only dismissed for default by the earlier advocate, my lord. The petitioners are suffering, my lord. This is the things, my lord. They are continuing. They are not discontinuing. And it is also admitted that they are continuing. So only for the question of the default of the advocate, my lord, the petitioner will be suffer, my lord. That is the question, my lord. This is a better number. They are continuing there since 2003, not now. 20 years they are continuing in service and getting salary also.
Good for you.
So on merit, my lord, on merit, it may be hard, my lord, by the honorable single bench, my lord. So your lordship may kindly remind it to hear the case on merit by the honorable single bench, my lord. This is my humble prayer, my lord. Otherwise, my lord, the petitioner will suffer only of this for default, this for non-prosecution by the advocate, previous advocate. This is my prayer, my lord. Otherwise, I have no case at all. Otherwise, I have no case at all. In the earlier at the time of admission, my lord, I have also mentioned before your lordships, and this bench, my lord, admitted my submission and passed the interim order and continuing.
Who's for the other side?
This is my case, my lord. Otherwise, I have no case, my lord.
My lord, here the page.
And he also not served the copy to me, my lord. File the rejoinder. That copy I have received. That vacation petition I have not received.
What do you say, sir?
This is for orders today, my lord.
Sir, when I ask him, you keep on replying. I'm asking him questions, sir.
Will
you permit me to ask him a question? Will you permit him to reply?
I am sorry.
My lord, here your lordship will find the impugn order at page 21, which the appellants have challenged in this appeal. My lord, this order was passed in an introduction. That was not in step of CMAPL like that one after dismissal of the writ petition. The proper forum is that to file a CMAPL. Second thing, my lord, rightly your lordship pointed out that for 13 years they have not filed the requisite. So notice could not be issued.
Right.
They have entered the interim order passed by the honorable single judge. And this is a case, my lord, by virtue of the judgment of this honorable court that declaring all the selections made of Sechasibi Sichasahaka pursuant to their particular declared to be null and void, and thereafter the opportunity was given to those persons to participate in the subsequent selection process. These persons, they participated in the subsequent selection process, but they did not become successful. Therefore, their services were terminated with after issuing the so-called notice to them and observing the formalities. So the some other persons also they claimed for their re-engagement and their claim was not entertained by this honorable court. They approached the honorable Supreme Court. Supreme Court also confirmed the order of this honorable court by dismissing the writ petition.
The prayer is for regularization.
Prayer for re-engagement.
Oh,
because they are by virtue of one common judge, all were declared null and void.
How can we restore a reputation only for 5 years? although the interim order is vacated by the single judge itself.
Yes, ma'am.
On 29 June 2006. Just read the impugned order.
Yes, 29/6/2006. Yes, ma'am. 29/6/2006.
They vacated the interim order.
Yes, madam.
And still they continued. How is that?
In this this appeal, the interim order was again passed. That's why the interim.
Sir, just try and follow what I'm trying to.
My lord, yes, yes.
The single judge vacated the interim order on 29th June 2006.
Yes, madam.
The writ petition ultimately was dismissed on 16th May 2019, 13 years thereafter.
Yes.
How come they continued in service for 13 more years despite the interim order getting vacated?
The interim order was, the vacation of interim order was not, that was not on the basis of the application of the state, and that was not been in the knowledge of the authorities. But
this is very remarkable. So the authority does not even know whether it is a stay order or not granted by the court.
No, stay order was granted, but
vacated by the single judge, sir, in 2006.
Due to on the date of that non-appearance for both the parties. On that date, there was no appearance.
So for 13 more years, they continued.
That your lordship's question is very pertinent, my lord. For last 13 years, they were continuing. But
how are they continuing for 13 years?
But one thing, my lord, their very inceptional engagement on the very inception has been declared to be null and void.
So, but doesn't seem to see, this is all not communicated to your officers, even by you. Your officers are very kind-hearted, sir. They are not bothered about all this. They are continuing to pay them, continuing in service. Only in court, all this. But your officers are very happy to let them continue. So even today, if you dismiss a writ appeal, they will continue.
No.
Yes. Yes, they will continue.
No, had that been
of course. It doesn't seem to make any difference whether somebody vacated a stay, granted a stay, nothing.
No, that IA has been filed for vacation of stay. That itself.
That also, then you go sleep. You file an IA and you forget. Interim order. Interim order got vacated in 2006 itself.
No, but that on 16/1/2020 in WA, that interim order passed, my lord.
That is all right. So anyway,
16/1/2000.
For 13 years, there was no interim order.
Yes, my lord. That is true, my lord.
We will restore the reputation without interim order.
Without interim, my lord, then your lordship may given liberty to me that I will approach the authority for continuance of the service. That liberty may be given.
Then we'll dismiss this. Then that you take that liberty. Then, if you have to approach them for your re-engagement.
No, your lordship may restore the writ application. I will go there and go there and make another thing. I'll file the petition before the honorable single bench.
Cease to be in employment, correct? The minute we only restore the petition, don't have interim order, only cease to be in employment.
Then you only restore the application. Then I'll file the petition there, my in this case.
And how come only 5 of you have come? You are 19 of you, no? Before the single judge?
Because they are, in the modification.
Working as? What are you working as?
We are at the Shiksha Sahayak, my lord.
No. So before, in the writ petition, there were 19 of you, I think. In 24 people in the original writ petition.
My lord.
What happened? You abandoned all your colleagues.
Others are not, others are already disengaged. Only 5 persons are there. They continue. Others are already
You had special arrangement in the department. Just see what is happening in your department. And he's making serious leavements before.
I am only 5 persons and they are continuing. Others are already disengaged since 13 years.
I'm telling you, they will continue irrespective of orders. They don't require court orders to continue.
Not only this is the district, my lord, in the Ganjam district also, some person will continue, some person are disengaged.
No, if you go further, it will not be that person who's continuing. Somebody else will be continuing. Sometimes I was telling Mrs. Raman some time ago, we break our orders thinking, deciding something. On the ground, something else is happening.
Because in the writ application, I am not the advocate. After dismissal, I came by. Earlier, another advocate was there.
And also in this appeal, also the petitioners have not challenged the order of dismissal passed by the honorable single judge.
I know.
They have challenged the order passed by in the interim application, not restoring.
Yes, this is the order. This is the final order.
That's true. That order you not change, sir. What do you do now?
My submission before Lordship only restore the case and it will come hard on merit.
No, we can only restore the application now.
My lord.
For recall and only for fine.
Yes, sir.
Are you taking any steps for these persons? Swachhasevi Shiksha Sahayak?
Swachhasevi Shiksha Sahayak they were, but now the Swachhasevi Shiksha Sahayak that
whole thing's been abolished.
That is abolished.
Then?
No, we are now on junior teacher.
They are these 5 are
now this,
they are junior teacher.
This repetition relates to Swachhasevi Shiksha Sahayak.
Yes.
Now he is claiming that he is a junior teacher.
Junior teacher contractual. Yes, junior teacher.
Then that means you have allowed them to be junior.
No, that I am not disputing that they are not continuing. This is the.
No, I'm not saying about continuance.
Subsequent.
I'm saying about Swachhasevi Shiksha Sahayak has been converted to junior teacher and he is continuing as
No, that is not the exactly conversion. Upon completion of particular time limit,
3 years.
Swachhasevi Shiksha Sahayak, they were observed at.
Given them the upgraded class.
Yes, that is there.
Then what remains in the writ?
2006, by that time they were already 2 junior teachers because all these disengagement, all this happened in 2006. So they were engaged in 2003. Upon completion of 3 years in 2006, first they were upgraded to junior teacher. Thereafter,
see, the problem started because they filed the IA. If that IA had not come up, they would have simply continued. You would not be aware. They would have continued. Because of this IA, all the trouble started. Some lawyer said, oh, you have to restore. It is dismissed for default. And they woke up in 13 years to the court to restore it. It's a mess, complete mess. It's just to permit them to file a representation. All these others 20th December 2019, passed by the learned single judge, restored, declining to recall, passed by learned single judge in IA number 17614 of 2019, in writ petition civil 5031 of 2006, whereby the learned single judge declined to recall an earlier order dated 16th May 2019, dismissing the writ petition for non-compliance of an order dated 20th April 2006. Paragraph. Background facts are there. The aforementioned petition was originally filed by 24 persons who claimed to have been engaged as Swechasevi Sikya Sahayak (SSS) way back in 2004, but were disengaged pursuant to orders made by this court, but orders passed by the court whereby the learned single judge in writ petition civil 11748 of 2003 in which irregularity committed in the selection of SSS was noticed, and all orders of irregular selection were asked to be cancelled. Stop. The writ petitioners were not thereafter re-engaged, and accordingly filed the above writ petition inter alia for a direction to the opposite parties to re-engage the petitioners. It appears that initially in the said writ petition, while issuing notice on 20th April 2006, an interim order was passed to the effect that if the petitioners were continuing as SSS and were discharging their duties, open quotation, they shall not be terminated without leave of this court, full stop, unquote. In terms of the order, requisites were to be filed by 24th April 2006, full stop. On 29 June 2006, when the matter was listed, none appeared for the petitioners. Full stop. Since it was noticed that requisites had not been filed, the interim order dated 20th April 2006 was vacated. Full stop. This order vacating the stay was not challenged. Full stop. Paragraph. For 13 years thereafter, the writ petition was not even listed. Full stop. However, for some reason, it appears that the said writ petitioners continued in service. And in the meanwhile, after abolition of the posts of SSS, were even continuing as single quotes junior teachers, unquote. Paragraph. The said writ petition was listed before the learned single judge on 16th May 2019, when it was noticed that even till that date, requisites had not been filed for issuance of notice to the opposite parties. Full stop. The learned single judge declined to grant further adjournment in the matter and dismissed the writ petition for non-compliance with the order dated 20th April 2006. Paragraph. Thereafter, the writ petition, the present filed IA number 17614. IA number 17614 was filed for recalling the above order. The said application has been dismissed by the learned single judge by the impugned order dated 20th December 2019, noticing the above facts. And finding no justifiable reason to recall the order dated 16th May 2019, dismissed IA number 17614 of 2019. Paragraph. While admitting the present writ appeal, while issuing notice in the present writ appeal on 5th March, on 16 January 2020, when this court was informed by counsel for the appellants that the appellants were continuing in service court directed that open petition, if the appellants are continuing service, they shall continue till the next date, unquote. Paragraph. It may be noticed here that although the petition was filed by 24 persons, the present writ appeal has been filed only by 5 of them. Paragraph. There is no valid explanation offered by counsel for the appellant for the failure by the appellants to file the requisites for 13 long years in the writ petition. Full stop. The explanation that the earlier counsel was negligent in failing to file the requisites does not impress the court, as the petitioners, as the appellants ought to have followed up with their counsel on the fate of the writ petition, which they clearly failed, which they did not do. So, in other words, the appellants were not diligent in ascertaining the progress of the writ petition. Full stop. Paragraph. There is a technical difficulty too, in as much as in the present writ appeal, the appellants have challenged only the order dated 20th December 2019, single judge, and not the 16th May 2019, by which the writ petition was dismissed. Full stop. Paragraph. Be that as it may, with there having been no interim order in favor of the appellants for a period of 13 long years between 24th April 2006 and 16th May 2019, there is no equity in their favor for continuation of any interim order. Paragraph. Restoring the writ petition at this stage would not serve, therefore, any purpose. Restoring a writ petition without any interim order would not serve the purpose of the appellants. Full stop. Paragraph. In effect, the court is unable to find any ground for interfering with the impugned order dated 20th December 2019. Full stop. Counsel then submits that the appellants will approach the state for their re-engagement in accordance with the existing policy of the government. Full stop. It is clarified that this order dismissing the writ appeal and vacating the interim order would not come in the way of the appellants doing so. Paragraph. The interim order dated 16 January 2020 is hereby vacated. It is dismissed. Right. 16 January. Yeah.
Item number 38.
Item 38, my lord. My lord, this IA has come up for consideration for condonation of delay, my lord. The delay of 198 days, there is a delay of 198 days, and the appellant was suffering from hepatitis, and a medical certificate corroborating that fact has been annexed with the IA. My only prayer is to condone the delay, my lord. My lord, the appeal was to be preferred within a period of 1 month. And he was suffering from hepatitis from, it's a viral infection, my lord. He was suffering and he was on bed rest from July to December, my lord. And already the winter vacation had ensued. My lord, there are the appeal, my lord.
What's the main matter about?
My lord, the main matter is that the learned single judge, we had challenged the 287th meeting held on 22nd January 2019, wherein the State Transport Authority had delegated its power to the power to entertain and dispose of applications with regard to national permit to the Regional Transport Authority. My lord, they cannot do that because, my lord, in the Odisha Motor Vehicle Rule 1993, Rule 43 subclause specifically states that the disposal of an application in relation to national permit shall be made by the State Transport Authority. There is no scope for delegation of the power to the Regional Transport Authority. And my lord, pursuant to that meeting, my lord, where the decision was taken by the STA, they have also issued a letter to all the regional transport officers, wide letter dated 12/3/2019, intimating that they shall be conferred with the powers of entertaining the national permit applications, my lord. Which is, my lord, basically in contravention of rules, my lord.
How does it harm you that you can get a national permit from Regional Transport Authority?
My lord, the power is vested with the State Transport
From your
Authority.
point of view, how does it make a difference? It's like
My lord, I have
having something more close to you for applying and getting a national permit.
My lord, I had applied, my lord. I had applied. They refused my application when I approached the Regional Transport Authority. My lord, I have faced hardships, my lord.
No, what meaning what?
My lord, they did not accept my application and my lord.
Why? I mean, so on merits, what is the case on merit?
My lord, my only point of submission is they cannot delegate the power, which is not permissible under law.
No, how is that? Why are they rejecting your application? There must be a reason for rejecting your
They
application.
have not rejected. They have not entertained my they have not accepted my application at all, my lord.
No, what is the prayer made in that regard? Did you actually pray in the writ petition that your application should be accepted?
My lord, I am challenging the decision of the STA, my lord.
How does it help you? You ultimately have to get a permit, correct? You want a permit.
I want a permit.
So without your application being accepted, how will your permit be?
My lord,
And you've not made any prayer for that.
My lord,
there is no prayer in your writ petition for that.
My lord, my lord, I had.
So this becomes an academic exercise about challenging the delegation of power and this and that. You might succeed in the writ petition, but you will not get a permit. Will that serve your purpose?
My lord, there is a lot of hassle being faced by the normal people.
From your point of view, let us say everything gets streamlined, but you don't get a permit in the end. So what's the whole purpose of the writ petition being entertained and all this judgment being granted? No purpose being served.
My lord,
it's become a pure academic exercise.
My lord, the ST has time and again delegated powers which is not permissible under law.
How does it help you to argue that and to succeed in that point? Because you are at the end of the day, even if you succeed in that argument which you're making, you don't get a permit.
My lord, I may get a permit if I apply to
So why should the court be wasted time
I have already
entertaining some academic question like this?
My lord, may allow me one day at least. I'll apprise your lordship in that regard, my lord.
No question. Tell us what is wrong with this single judge's order. Come, let's come to that now.
My lord, can I ask for a little short passover, enabling me to prepare better?
Or pass.
Item 39.
Please, lords. This is my lord. Here the petitioner has challenged the
Order of the Honorable Single Judge,
What's the delay?
Annexure 6, Your Lordship. Page 22, Your Lordship. So on the sole ground that the petitioner has challenged the order of the state level scrutiny committee on the basis of the minor violation of natural justice. Because Your Lordship knows, Your Lordship, 3 witnesses behind the back of the petitioner by the IO, was those witnesses were never produced before the committee to cross-examine them. Your Lordship, the division bench judgment already before Your Lordship that since it is a quasi-civil proceeding, they has to follow the natural justice as per the Madhuri Patil judgment, and all the witnesses who have been examined by the IO behind the back of the petitioner should have been produced before the committee, and the petitioner should be given the opportunity. In this case, Your Lordship, order Your Lordship C, page 25, Your Lordship, relevant page. Your Lordship, otherwise also the witnesses who have been examined, the IO that the petitioner belong to the panel. The IO who have been examined by the IO, they should have been published before the committee. That is my, Your Lordship, the order of the committee, Your Lordship C. Order of the committee, my Lord, Annexure 2, Your Lordship, relevant page, Your Lordship C, 19. Sorry, page 20, Your Lordship. Page 20, Your Lordship, relevant page. From the statement of the witnesses attached to the IO report, it is found that the alleged belong to Pana Christian. Your Lordship, my judgment of Your Lordship, my Lord. Relevant page, my Lord, 68 para 6, Your Lordship. Relevant page,
So
my Lord,
first
68 para 6.
We'll come to the facts of your case, sir. Before reading any judgment, we would like to see the facts of your case.
My Lord, my contention here, my Lord, Your Lordship, read petition in the paragraph 11, I have specifically alleged, Your Lordship, contended that
you wanted to show that you belong to a scheduled tribe, correct?
My Lord. Your Lordship, paragraph 11, page 4, I have specifically contended that the committee has relied upon several documents and the report and the statement of the witnesses. Those witnesses who have been examined, that is my plea, should have been produced before the committee, and I should have given the opportunity to them whether they know about my tribal status. But they have never produced before the committee.
No, what you wanted to be, you said you belong to which scheduled tribe?
My Lord. Because my Lord, several documents they have produced.
No. Which scheduled tribe did you claim to belong to?
Kondho, my Lord. Kondho.
Whereas you are actually a Pana Christian.
No, that is a report of the committee, my Lord.
So clearly state your facts first, sir. When you argue a matter, we don't straight away start arguing. See para 15 of judgment of the Supreme Court. First, you speak about the facts of your case. So you are claiming to be a Kandha, whereas you have been found to be a Pana Christian.
But to reach the conclusion, as per your Lord's Madhuri Patil judgment has prescribed the procedures.
No, you are running to judgment. First, we have to stick to your facts first. Then judgment will come later. First, facts.
The report of the committee, Your Lordship C, paragraph, Your Lordship. Committee, page 2, page 18, Your Lordship. Your Lordship, in this case, while reaching the conclusion, in page 20, Your Lordship, in page 20, in the paragraph 5, from the statement of the witnesses attached to the IO report, it is found that the alleged belong to Pana Christian. My Lord, these witnesses who have been examined behind my back were never produced before the committee to at least cross-examine them. What they know about me. That's the opportunity.
Has anyone spoken positively that you belong to a Kandha caste? This is all about negative.
Negative, my Lord. That's why I should have.
Where have you any Kandha?
So far, the witnesses.
The certificate obtained by you is found to be fake.
No, that is the allegation, my Lord.
That's right. So the onus is on you to show that it is not fake, correct?
My Lord, I have in the writ petition itself, Annexure 3 series, I have given the affidavits.
Yes.
Affidavits I have produced before the committee that was also not taken.
Just come to page 19.
19. 19, my Lord. It is specifically in page, paragraph 1, my Lord. It is evident from the IOS report that the alleged and his family members have belong to Pana Christian and Pana by caste and Christian belief.
Let's review now.
Para 2. Let's
read para 2, sir.
Para 2, my lord. Before the SLC such and such.
No. Why are you running? It is found.
Para 2, my lord. It is found from the statement of the alleged before the SLC on 39/2009 that he belongs to Pana Christian by birth, as his father Daniel was Christian. Further, he stated that after the death of his father, when he was about 12 to 13 years age, adopted to Chakrapani Pradhan, who happens to be the grandfather Jajewappa, the maternal uncle of his late father. The said Chakrapani Pradhan also belonged to Christian community, but besides, it's filed by the Chakrapani Pradhan, summarized before the executive magistrate. He would agree. On 9/4/79, the alleged has not produced any adoption deed to this regard. Further, he stated that in his statement that he has stated in his statement, he along with his mother who reconverted to Hinduism, could not say the exact date for reconversion. So also has not.
How come reconversion to Hinduism will make you Kando?
No.
What have you argued? I don't know.
That is not
your counterpart or whoever has argued has done a very bad job, sir.
My lord. So for my lord, the affidavit of the Chakrapani, I should have produced before the committee. They should have consideration all these things.
So without all this, how will all these judgments help you?
Well, my lord, so the since your lordship, whole thing is natural justice should have.
What is natural justice? Natural justice, if you have some solid material, then natural justice.
Well, where the lack of.
Have you seen the law on natural justice? Natural justice is not simply natural justice for the sake of natural justice. If you really have a solid case, then you show that if I had been afforded natural justice, I would have won in my case. Now you have no material at all.
No, in this case, where there is a lack of documentary evidence, there should have been
a question of
oral evidence. There should have opportunities should have been given.
Dismissed will pass the detailed order. Right. Delays condoned.
I beg your pardon, item number 8. Lordship has the council is present.
Ask him to.
Item 8.
Your Lordship,
Yes.
petitioner challenging order at annexure P7, page
Sir, we
67.
wanted to pass an order in your favor, but your instructing counsel prevented us from doing that.
Your Lordship, I will be deeply obliged if you passed an order in my favor.
And now we are having doubt. You could have passed it when he appeared. We don't know. We should have passed it when you appear.
Your Lordship.
This is only on a lighter note. So I wanted to know whether you've paid the 10% tax at the time of appeal.
Yes, your Lordship.
All right. So the standard order that's being passed is subject to your paying 20%.
Lordship.
All right.
Your Lordship, I have a humble petition before your Lordship.
Yes.
Since the whole demand is only on one account, instead of considering the sales return figure as a reduction, assessment authority has added it. So
We are still at the stage of notice, sir.
No notice.
You don't want notice to issue.
Adjudication order has
Then
been
you do not want notice to issue in your petition.
My humble petition is matter may be remanded to the adjudicating authority for fresh adjudication.
Fast for the whole system. Usually in a new writ petition, we issue notice, we ask them to file replies. After considering the replies, we pass orders.
Your Lordship.
We are unable to allow the prayers today itself, sir.
Okay, your Lordship. Deeply obliged, your Lordship.
All right. Notice, same order. Just on 4th May. He's already switched off. He's a very busy counsel, looks like.
Obliged, your Lordship.
All right.
So I'm appearing on behalf of opposite partner 345.
Correct.
Extra copy to be served.
Please serve.
I'll serve.
Right.
Supplementary list item number 40.
Yes.
Supplementary list item number 40.
None appears to be dismissed.
Item 41.
May I please, Your Lordship?
Yes.
The present appeal has been preferred against the order of Honorable Single at annexure 1, Your Lordship, page 15.
Delay is condoned. Yes.
The order dated 5th of December 2019, Your Lordship.
Yes.
I'll just place that order, Your Lordship. Heard Sri S.K. Nath, Learned Counsel for the petitioners, Sri A. Mahanti, Learned Central Government Counsel, appearing for opinion number 1, Learned AGA, appearing for opinion number 2 to 4, so and so. There is no dispute at bar that the dispute involving the petition is already covered by the decision of the division bench of this court in disposal of WPC number 5358 of 2009 on 28th of November 2019. In such view of the matter, this court disposes of the petition, directing the opposite parties to work out the claim of the petitioners as per direction contained in the above petition. Now, Your Lordship may kindly look at what was the order dated 20th of November. थोड़ी 538 to 2019. I'm just placing the order, Your Lordship. By way of this petition, the petitioners have challenged the action of the opposite parties in publishing a request for proposal RFP bid as per the advertisement dated 22nd of February 2019 for hiring of agency to provide manpower support to rural sanitation work. Mr. P. Acharya and senior advocate appearing for the petitioners submitted that in the year 2005, the petitioners, after being successful in a selection process, were appointed as district project coordinator DPC, level consultant DLC, and assistant project coordinator AP. on contractual basis. While continuing as such, the opposite parties, instead of extending the contract period, published advertisement to fill up those posts through outsourcing agencies. It is a submission that the idle employer like the state government cannot substitute contractual employees who are in employment through another set of contractual employees. He has mainly relied upon the decision of the Honorable Supreme Court in the case of State of Haryana and others versus Pyara Singh and others.
But are you contract labor?
My Lordship?
So contract labor, is it?
I'm contract labor, Your Lordship. I am district-wide coordinator who have been appointed through contractual basis, Your Lordship.
Contractual basis means not through an labor contractor.
No, not for directly from the state, Your Lordship.
Oh, I see. Okay. So what is your problem with the...
Yes, Your Lordship. Now, I'll just take 2 minutes, Your Lordship. I'll just place paragraph 5 of that order.
Yeah.
Since the petitioners were appointed on contractual basis, ends of justice will be served if the petitioners who have served under the state government for more than 5 years and they are experienced, if they are otherwise eligible, they should be given preference for appointment to be made by the contractor who has been selected through the impugned advertisement. My case is against the very same order. A review application be preferred, Your Lordship. Now, what was the difficulties? There was 2 sets of writ applications. One preferred by these contractual employees in their personal capacity, and another writ application by their association. The main prayer of the contractual employees was to quash the tender and to allow them to continue in the service. Now, the writ application association of their service, as they have worked for more than 14 years within the state, Your Lordship. Now, the whole difficulty is in the association, there are more than 100 employees, Your Lordship. More than 100. Now, in the advertisement, the contractor, he has only advertised for 48 vacancies. Now, even if the petitioners, they're eligible, that is still, Your Lordship, they're eligible. Otherwise, they could not have continued for 14 years. Now, because of the impugned advertisement, half of the employees who were earlier working are they out of the service, Your Lordship. For that purpose, a review has been sought, and the present appeal, which was disposed of by the Honorable Single Judge. But my prayer is, Your Lordship, until I
but this 5358 is by the association.
By the individual employees, Your Lordship.
This is by individual employees.
So my humble prayer is, Your Lordship, the same may be tagged with the review petition, but that has to be heard analogously. Why I'm saying so, Your Lordship, there is a reason. Because, Your Lordship, in the association, there are more than 100 employees. Now, they have engaged around 20-30 employees, they have been engaged. The remaining are out of service. This aspect has not been dealt by the Honorable Division Bench as well as the Honorable Single Judge, Your Lordship. And even if I have worked for more than 14 years, Your Lordship, teams in the state of Orissa, they've been regularized after 6 years of service, 10 years. My Lordship already knows they are the Sikhya Sahayaks, Your Lordship, who have absorbed in that post after 6 years of service, Your Lordship.
That there has to be a scheme for that.
Yes, Your Lordship, there is a scheme. That's what I'm saying, Your Lordship.
Is there a scheme in the this water sanitation board? There is a scheme for regularization.
There is no scheme, Your Lordship. That's my mistake. Yes.
So without there being a scheme, how can you simply ask for regularization?
Yes, Your Lordship. But my only contention is even if by applying the Uma Devi, the state of Karnataka was Uma Devi, 2006 Supreme Court, Your Lordship, I have worked more than 14 years, Your Lordship. I sweat my heart. I work for the.
So even Devi would only take you up to a scheme.
My Lordship.
It will have to be regularized in terms of a scheme. So if there's no scheme at all, then Uma Devi again cannot.
That was the main in this writ application. That was the main prayer, Your Lordship. Because as I have worked for more than 10 years, at least I should have given some concession. Now, I should kindly visualize a person who is engaged in 25 is now age barred for all purposes, Your Lordship. Even he cannot be employed in any other government service. That's why appeal has been prepared, Your Lordship, to bring out all this agony of the petitioners.
No, that is one part of it. But the question is, how much can the court do in light of Uma Devi and all these?
The purpose.
All these orders require there to be a scheme and for being considered for regularization in accordance with that scheme. That's all.
I bow down, Your Lordship.
Yes.
So until
if you're now out of service, the question of regularization does not arise.
Doesn't arise, Your Lordship. So my limited prayer is, Your Lordship, if by virtue of the order passed by the Honorable Division Bench, if we could have been accommodated, there is no reason for filing this appeal, Your Lordship. Now, my Lordship may kindly understand the situation. These petitioners, they have been throughout the service of 14 years, Your Lordship. They have been working. Now, the intention of the Honorable Division Bench was to accommodate them in the vacancies. But now, because of the advertisement, when they have published only 40 vacancies, half of the petitioners, they are out of service now, Your Lordship. Can be accommodated. Let the state take instruction. If they can be accommodated, then my lordship, it can be very, very disposed of on that light.
Actually, this writ appeal itself is coming up after 3 years after the order of the single judge. So in the meanwhile, we don't know how many more.
Let them
is
take
there any fresh, award of the contract to anyone?
As far as my instruction is concerned, Your Lordship, there is no other requirement that has been taken over. Let the state take instruction. If there's so vacancy available, they can be accommodated, my lordship. Where they will go at this stage, where they will go after 14 years, Your Lordship, 17 years now. In the meantime,
what
review petition number 28 of 2020, Your Lordship.
28 of
2020.
It is stated that against the order passed by the division bench on 28 November 2019 in writ petition civil 5358 of 2019, a review petition was filed by the individual petitioners in that said petition. Accordingly, it is directed that the present appeal be listed along with review petition number
28 of 2020.
28 to 2020. Oh, this will have to go to a separate bench then.
Compassion of Honorable
which is Patra's member on 3rd February.
I'm grateful, Your Lordship.
Item 42.
In item 42, I'm on VC, my lord. The case is I had applied for Anganwadi worker in 2009, and I was duly selected by the selection committee consisting the sub-collector of that area as the chairman. The page, unfortunately, is in a vernacular language, but my associate is there in the courtroom. He can forward copy of the English circular, my lord. So there what has happened, I have been duly selected, and my selection list, which is at Annexure 17, at page 17, Annexure 2 of this paper book, my lord. But now what has happened, unfortunately, the respondent number 5 out here, he has been given the posting as against my selection, my lord. At single judge, at page 12, my lord, read out the page 12 of the paper book. The Lordship has got it. Having regard to the amendments made in the petition and considering the contention raised by learned counsel for the opposite parties, this was issued by the CDPO Tangi, inviting applications from the eligible candidates for filling up the post of Anganwadi worker in respect of Pathan Sai Anganwadi Center under Tangi block in the district of Khorda. Pursuant to such advertisement, the petitioner and opposite party number 5, along with others, submitted their application. As it was found that the petitioner does not belong to Anganwadi Center area, her candidature was not taken into account. And opposite party number 5, having secured highest mark and satisfied the eligibility criteria, was selected and engaged in Anganwadi work center under Tangi block in the district of Khorda. Needless to mention, the Anganwadi worker Anganwadi Center area has been finalized by the standing committee. If the petitioner does not belong to the Anganwadi Center, her claim should not have been taken into consideration. So now, if a lordship will see the circular of the sub-collector, which my associate is, they will just pass on. That clearly says that I elected. And basing on that circular, CDPO again issued another circular that is at page 11 of my paper book, my lord, page 17.
Yes.
Page 17 is in the Oriya language, but this circular is arising out of that standing committee report, my lord, where my name figures at serial number 20. But thereafter, I was never given the posting.
Yes. No, but you do not belong to that center.
No, I belong to that center. If your lordship will come to page 14 of my paper book, Annexure 2, is in Oriya language, but this clearly says I am similarly placed as that of the respondent number 5, my lord.
No, the finding of the single judge is that you do not belong to that area.
No, that is what I'm trying to say, my lord. If your lordship will see Annex 2 at page 14, though it is in Oriya language, I and this respondent number 5 are of the same place, same area, everything is same.
But
I can file as a translative.
No, but in terms of marks, who scored higher marks?
I scored the highest, my lord, because I scored 70.3, whereas she scored 53. But because my name was deleted, so her name came as the highest scorer at 53, my lord.
You are the selected candidate.
I'm not the.
No, he's my associate, my lord.
Yes, Mr. Kuntia, what's
that order says she does not belong to that center area. And as per the notification of the government, if one does not belong to that center area, even if
he says she does belong to that area, I don't know.
There is no document she has annexed to that.
Page 14, my lord, page 14, Annex 2. It's in Oriya language.
That's the select page 14. That is only the name of the candidates.
No, everything is the area is also mentioned there.
Mr. Kuntia, in Annex 2.
Annex 2, page 14.
Third, fourth line.
Sanjog Gramo Gudikar Namo.
Fourth line.
Yes, that is Sanjog Gudikar. That is the
Janch Pore. After verification, following candidates' applications were selected for
appointment, my lord. Nimonte jo ke bibechit hoichendi mane they were duly selected.
They were found eligible.
Yes,
my lord.
So that is what the sentence says.
Then I take instruction.
No, it says a notice. He accepts notice on behalf of the respondents 1 to 4, and then notice be issued now to respondent 5 by registered speech post. Returnable on 17th April.
Oh, bless.
Item number 43.
Right.
Yes.
Item 43.
But at item 43, the present writ appeal emanates from the review application. The original order, which is challenged, that is WA number 110 of 2020. Your lordship may call for that record.
How can a writ appeal be filed?
But here what had happened in abandoned caution, I filed because in the re-application, I was the private opposite parties. We were noticed, some were noticed, there was no substitution of one of the deceased opposite party. There was no, one of the parties was not even made party in the writ application. For that, as we could not appear, we filed a review. Against that review, I have filed one writ appeal, but against the original order also, I have filed the writ appeal.
No, against the review, how is a writ appeal maintainable? I don't understand.
My lord, I brought to the knowledge of the Honorable Single Judge that these parties were not constituted, and one of the parties was not even made a party in the writ application, though he was a party in the revisional court. The revisions or the commissioner's revision order was assailed before the Honorable Single Judge. That I brought to the knowledge of the Honorable Single Judge by filing a review. All the co-sharers, when some of the co-sharers substitution was not there, some of the co-sharers were not even made. And the application was allowed, setting aside the revisional order.
List along with writ appeal number?
110 of 2020.
110 of 2020 on 16th March.
Madam.
Item 44.
Please, this honorable court. Sir, I challenge the impugned order dated 17 January 2020, passed by Honorable Single Judge, PC number 430 of 2020, my lord. At page 25, the impugned order, my lord, may kindly see page 25. considering the submissions made in the facts and circumstances of the case, further keeping in view of the prayer as has been advanced, the court is not inclined to entertain this writ application. This is the only judgment without any cogent reason. My lord, Learned Single Judge has dismissed my writ application. My only prayer was for a direction to the opposite parties to dispose of my representation.
Yeah. Let the representation. You say.
But encroachers are not made parties. Encroachers are not made parties in the writ appeal or before the writ petition. Let me say that
they are not
somewhere encroachers, they are not made parties.
So we'll clarify that the disposal of the writ appeal will not prevent you from making a fresh representation, naming the encroachers. You see, although the writ petition of the present appellant has been dismissed by the Learned Single Judge with a non-speaking order on 17 January 2020. It is seen that in the main writ petition, the alleged encroachers whose eviction the petitioners were seeking were not made parties. Full stop. Therefore, no purpose would be served in merely restoring the petition to file. Stop. It is therefore clarified that notwithstanding the dismissal of writ petition civil 430 of 2020 by the impugned order of the Learned Single Judge, it will be open to the petitioners to make a fresh representation to the authorities, naming the encroachers whose eviction they are seeking, and after following up on such representation to seek appropriate remedies. The writ appeal is disposed of in the above.
Item 45.
This writ appeal is arising out of CMP passed in order dated 21/8/2000. 21/8/2019. We are challenging the order passed in CMP, wherein the single judge has passed the order. Operative person of the order to substantiate the at page 19, to substantiate the case of the petitioner 2 was examined at PW1, the treating that doctor was examined, and PW2 the medical certificate issued by the doctor has been exhibited. There is no reason to disbelieve the medical certificate issued by the doctor, but then the conduct of the petitioner is not free from blemish. The fact narrated above shows that the case has been dragged for several years for the laches of the petitioner. In order to give a further chance to the petitioner to prosecute the first appeal, Mistake number 6 of 2014, as well as CM number 13 of 2015 are allowed. The lawyer applicant.
No. What modification were you seeking of the order dated 21st August? You sought a modification.
Subsequently, that was not allowed by that.
What is the modification you were seeking?
Well, order was passed directing to deposit 28% for restoration of the CM and CM. 25,000. The petition is a BPL category, my lord.
Sorry?
BPL category.
Whatever, sir. You have not been diligently following your petition. That's what the order says.
Subsequently,
and it's as it is, writ appeal may not be maintainable because it comes from civil proceedings.
But if the amount has been reduced, then it is likely to pay.
All right.
And petitioner is in possession since 1940. It's a leasehold property. And he is a permanent injunction suit is filed before that lower court. They are not accepted and be during consultation period that are not taken into consideration and petitioner suffered. Subsequent made an action with them.
The challenge is the present appeal. It's an order dated 20th December 2019, passed by the London single judge, dismissing IN number 1084 of 2019, whereby the appellant sought modification of an earlier order dated 21st August 2019, passed by the London single judge in CNP number 638 of 2017. Paragraph. The aforementioned CMP number 638 of 2017 was filed by the petitioner, challenging an order dated 6th February 2017 of the Additional District Judge Jashpur in CMA number 13 of 2015, rejecting the application of the petitioners for restoration of Miss Case number 6 of 2014. Petitioners for the defendants in TS number 175/1983 on the file of the Civil Judge Junior Division Jashpur. Full stop. An ex parte decree was passed against them. Full stop. They then filed an application to set aside the ex parte decree, which was allowed. Full stop. Thereafter, the petitioners contested the suit which stood decreed, and against the said decree, they filed RFA number 76 of 2006 before the learned ADJ. Full stop. By the impugned order dated, by an order dated sorry. The appeal is dismissed for non-prosecution. Full stop. Miss Case number 6 of 2014 was then filed by the petitioners for setting aside the dismissal order. Full stop. This Miss Case also was dismissed for non-prosecution. Full stop. Again, another application was filed to restore the said Miss Case number 6 of 2014, which too was dismissed. Full stop. It is thereafter that they filed CMA number 13 of 2015, which was dismissed by the ADJ. Full stop. The learned single judge, by the order dated 21st August 2019, gave one more chance to the petitioners to defend the said suit, subject to their paying 25,000 rupees to the plaintiffs within 4 weeks, open quotation, failing which, the order shall be automatically recalled. Just a one point. Claiming to be below the poverty line, the present petitioners filed IA number 1084 of 2019 for modification of the above order dated 21st August 2019 to waive the costs, which was made conditional for the suit to. So by the impugned order, dated 20th December 2019, the learned single judge declined to entertain the said IA, and hence the present writ appeal. Paragraph. Having heard learned counsel for the appellant and having examined the record, the court finds that at every stage the appellant has been lackadaisical in pursuing the matters in court. Full stop. The petitioner appears to have not been able to follow up on the proceedings at all. in as much as when a restoration application was dismissed for non-constitutional. Stop. In the circumstances, the imposition of a condition of deposit of rupees 25,000 by the petitioners, by the appellants, for restoration of the suit does not appear to be unreasonable to this court. The Lansing judge rightly negative the prayer for modification of said condition. Paragraph. No grounds are made out for it in the present appeal. Appeal is dismissed.
Item 46.
46, my lord, there is some delay, my lord. I have not filed the limitation petition. May I pray, my lord, 1 week time so that I will file the limitation petition thereafter?
Last opportunity to be petitioner, appellant to cure defects within a week. Yes, thereafter.
Item 47.
In item 47, I'm on VC, my lord. Here, what has happened? I was working as an Anganwadi center since 1999, and in 2006, on the ground that I was involved in the midday meal, which was being supplied by one particular self-help group, my lord. Lords, may kindly come to 23 for a moment, my lord. This is the notice issued by the sub-collector of Jharsuguda as serial number 3. It is alleged that you are directly involved in management of MDM of JRC primary and ME school, Brajrajanagar, without consent of WSHG members. And she was asked to give a show cause. And she gave a show cause, and that was not accepted. She was terminated. Then she filed an appeal before the collector. Then finally she filed a writ petition also, which was also rejected. My lord, you may kindly come to page 16. That is the impugned order, my lord. About 5 lines from the top, page 16. The collector Jharsuguda, on consideration of all the materials available on record and on perusal of the necessary documents, came to a conclusion that the petitioner was involved in mismanagement of MDM program of the school as secretary of Ma Lakshmi Self-Help Group till July 2013. Point field inquiry of DSWO, ACSO and BEO on 13/8/2014 at 10 a.m. The petitioner was found absent and no register, including maintenance, attendance register, etc., was found in the Anganwadi center. So now, if your lordship will come to page 22 for a moment thereafter. This is written in Oriya, though. This is a letter or a certificate issued by the self-help group who was managing the midday meal. They have clearly said that since 2007 they have been managing the midday meal, and this particular appellant was never involved, neither directly or indirectly, as far as the supply of the midday meal is concerned, or with regard to the day-to-day functioning of the self-help group. And my second submission is I was working for almost more than 50 engaged. This is all that I have to say, my lord.
No, but these are all factual findings, sir, and concurrent findings.
That is true, but this particular letter, the certificate at annexure 5, page 22, clearly says that I was not involved, my lord. Though it is it's a factual fact, but I mean, at least it can be relied upon to some extent, because looking at my career of last more than 15 years without any.
That's all. That's all right. You say the challenge in the writ appeal is to an order dated 26th February 2020, passed by the learned single judge, dismissing writ petition civil 16 filed by the assailing an order dated 9 December 2015, passed by the collector Jharsuguda, disengaging her from service as Anganwadi worker, AWW, in respect of the Doda Anganwadi Center, Doda AC, AWC, under the ICDS urban Brajrajanagar. Full stop. In turn, the collector affirmed an order dated 21st August 2015, passed by the sub-collector Jharsuguda. Paragraph. The disengagement of the appellant was purportedly on the basis of an inquiry into the allegations of serious irregularities, negligence of duties, and misappropriation of government money against the appellant. Paragraph. On the directions of the authorities, a joint inquiry was made by the district social officer, bracket DSW, and assistant district social welfare officer, bracket ADSW, on 11th October 2014. Full stop. The appellant was given a personal hearing, following which the sub-collector, Jharsuguda, by order dated 21st August 2015, dismissed the appellant from service. Paragraph. Against the order of disengagement, the appellant preferred an appeal before the collector Jharsuguda, who, after hearing the appellant, dismissed the 9th December 2015. Paragraph. In other words, the sub-collector and collector Jharsuguda passed concurrent orders, consecutive orders, sorry, affirming the dismissal of the appellant. Paragraph. The learned single judge, after noticing the above facts, also noted that in the joint field inquiry conducted by the DSWO, the appellant was found absent and no register, including attendance register, was found in the AWC. The appellant was also found to have made fake entries of underage children in order to misappropriate government. Paragraph. The termination being based upon an inquiry, the report of which has been affirmed even in appeal, but the court is not inclined to interfere in the matter. Full stop. The question turns purely on facts. And there's no basis on which the court will conclude that the orders of the sub-collector or the collector suffer from any illegality. Paragraph. There is no merit in the present interpretation. Writ appeal is dismissed as such.
May I just submit one more thing, my lord? As the lordship has observed that these are disputed question of facts. So can I be given liberty to approach the civil court if so advised, my lord?
No. Yes.
Item 48. Lordship, item number 48 and 49 are batch case, my lord. Similar matter has been heard at length and it's pending for order.
What?
Item 48 and
pending orders where?
Before Honorable Justice A.K. Sinha, your lordship. Arindam Sinha.
He's hearing, as a single judge, he's hearing writ appeal.
My lord, it was on 19/2/2021. It was ordered.
Referred to larger bench, my lord. This. They referred to larger bench, my lord. So the matter was heard by your Justice Arindam Sinha.
Larger bench means how can it be heard?
Three benches.
You didn't tell me the names of the other bench members.
The Justice Ponder and Justice Panigrahi were there, division bench. The matter was deferred. Thereafter, that was referred to the larger bench. Hard judgment that was referred to Justice Vishwik Mahanti after his retirement. Again,
as a third judge.
Third, sorry,
you have to say that. All right. Which are the numbers?
My lord, WA number.
No, but we'll have to simply adjourn this then. Because this can't go to Sinha, because in this there is no. Yeah. Those writ appeals are against the same impugned order.
My lord. Annexure 6 is the challenge.
But not against the same impugned order. In those cases, that honorable single judge has decided not to decline to allow their prayer for regulation. Here, my lord, your lordship may see this prayer. Here, my lord, he has made a prayer not to praise the writ petition. Your lordship may say Annexure 9. the impugn order. That is something different. Your Lordship, is page annexure 8, page 54. Here, he does not want to create petition.
Where is the question of entertaining an appeal against this? You have yourself made a submission that you do not want to press.
My lord, this was the order in before the single.
Correct. So why should we interfere with it in this writ appeal? Once you've told the single judge that you do not want to press the writ petition, where's the question of entertaining a writ appeal? The present appeal is directed into 2020 of the learned single judge. Disposing of writ petition civil 9609 of 2020. Stop the said order reads as under, reproduce the order. Paragraph. It is plain from the reading of the order that the appellant informed the learned single judge that she did not wish to pursue the writ petition. Press the writ petition. Stop. The court sees no reason why it should interfere with the said impugned order. Since it appears to be passed on the statement made by the appellant herself. No grounds are made out for interference. The writ appeal is dismissed. The next one is similar.
Yes, 49 is same.
Right. In view of the dismissal of writ appeal number 401 of 2020 today by this court by a separate order. The present writ appeal is also dismissed.
Item number 50.
Item number 55, please, Your Lordship. I am appealing to VC, my lord. This matter to come along with WA writ appeal number 261 of 2020, my lord.
What is that matter about?
My lord, it is about this regulation of services of the teachers, my lord. The petitioner had challenged in the writ appeal, my lord, which was rejected by the Honorable Single Judge. And in that court, by Honorable Justice Panda and Honorable Justice S.K. Panigrahi, my lord, one of them, they had a differentiated in this, and its matter is in the larger bench, my lord. Writ appeal number 261 by 2020 is still pending in the larger bench, my lord.
Let's see this single judge's order here. It's not a batch of matters, sir. It's each writ petition seems to be individually decided.
In this, in item 50, my lord, there are 3 appellants, and in similar cases, in the item 51, there are only 1 appellant, my lord.
So what is your grievance about the impugned order?
My lord, about the our main prayer was about the ad hoc employees for regulation of the services, my lord.
Correct. So come to page the impugned order, Annex 13, page 74.
My lord.
What is wrong with this order? They've been asked to look into the request for regularization.
My lord, if your lordship may have the glance in the page 74, the second last para, my lord, for the decision of this court is under challenge involving writ appeal number 234 of 2020, arising out of WPC number 110 of 2020. This court also observed dismissal of writ petitions shall not stand on the way of the petitioner getting the benefit, if any, granted in the disposal of the writ appeal number 234 of 2020. My lord, this is different, my lord, than what we have challenged in this one.
Yes. If it's different, you should not be prejudiced at all.
I beg, Lord.
How is this order against you, sir?
No, my lord. That is for the 234 of 2020, my lord.
No, the paragraph previous to that. What does it mean? Just read that.
Read that. I may read it, your lordship.
Yes.
Be that as it may, since decision on the claim of the petition, his regulation in terms of Rule 2013 is required to be taken by the opposite party number 1, Opposite part number 1 is directed to look into the aspect of claim for regulation by the petitioners, also looking to the aspect of applicability of Rule 2013 to the case at hand, taking into consideration the representation at the instance of the petitioners via Annexure 12 and take decisions appropriate within 2 months. In the event the post held by the petitioner are not filled up by the way of selection through Annexure 10, petitioners may be permitted to continue till a decision is taken upon by the OP number 1.
How is this prejudicial to you, sir?
My lord, this WPC number 12002 of 2020, my lord, and in the second last para, the WPC 11408, my lord.
Even there, they say the dismissal will not come in the way of your getting benefit. So either way, even both the paragraphs, there's nothing adverse to you at all.
The same is pending before your lordship in the larger bench. That's why I pray before lordship.
No.
Just come along with
tell
the
us
same
what is
matter.
wrong with this order. We find nothing wrong with this order.
That's different in our case, my lord. Our prayer in the writ appeal is something different for which it is.
What is your prayer?
In the writ appeal about the challenging the 12002 of 2020. I mean the same order where lordship, what my lordship already stated, and by the single bench, honorable single bench.
What's a termination order? No, same. You're questioning termination and asking for regularization. It's the same thing, sir.
My lord, the ad hoc employees for the regulation of the services.
Yes. The present writ appeal is directed against an order dated 29th May 2020 passed by the single judge disposing of petitioner's reproduction to of 2020. Paragraph. In the said writ petition, the appellants for inter alia seeking a direction to the opposite parties for regularization of their services, applying the provisions of Orissa Group B Post (Contractual Appointment Rules 2013). Full stop. In the impugned order, the learned while disposing of the writ petition of the Xander. Take the last two paragraphs, page 74. Be that as it may, and for the decision of this court. Paragraph. The court is unable to find anything in the above paragraph which can be said to be prejudicial to the present petitioner. So it is not clear why he is challenging the impugned order of the learned single judge. Paragraph. No grounds have been made out for interference. The writ appeal is dismissed.
My lord, let there be a simple adjournment in this matter.
51.
51 is also the same.
Same.
Item number 52.
Item 52, my lord. It seems that I have not sought a second copy. Second, I am not.
Yes, please.
But the impugned order is at page 45. The reason on which my writ petition was dismissed was that my claim was at a very latest phase of my later phase of the life. That is, just before the retirement, I made these claims. What my claim was, my lord, my relief in the writ petition was that my service which I rendered to OLIC, Orissa Lift Irrigation Corporation, may be taken as service by the state government and not as a.
You stopped being an employee of the Lift Irrigation Corporation long ago.
No, I was in the service. That is
no. When? When were you in service of Lift Irrigation Corporation?
I retired on the August 2020, my lord. After filing of this writ petition, retired. I was appointed under rehabilitation in the year 1981 in the Lift Irrigation Corporation, and I rendered my services. And in the year 2015, I learned that similarly placed persons who were appointed like me, their father was also my father's colleague, and they have been appointed under the state government, and my appointment was under the Lift Irrigation Corporation. So naturally, I'm losing the pensionary benefits. All this I'm losing, and this knowledge came in the year 2020. So therefore, I am aware that at the very back end of my career, but my one submission may kindly be considered that in the writ petition, my prayer was a kind of limited to disposal of representation, which was at page number 43, 44.
Anyway, now that's all gone. We've gone past that stage now.
Let the state government may at least take my representation.
All that statement must be made before you argue the writ petition. You argue it full-fledged, it goes against you, then you fall back on representation. Doesn't work that way. The challenge in the present writ appeal is to an order dated 11 September 2020, passed with the dismissing writ petition civil 19538 of 2020, filed with the present appellant, whereby you are seeking a direction to the respondent state to treat his service up to the date of superannuation to be under the state government and to be given retirement benefits along with pensionary benefits. Paragraph. Admittedly, the petitioner worked in the Orissa Lift Irrigation Corporation (OLIC) from 6th November 1981 till 31st August, that is the date of his retirement. Having entirely served his career in the OLIC and not having made any claim that he should be treated as an employee of the government, he could not be heard to say, make that prayer long after his retirement.
Just before the retirement.
Or on the verge of his retirement. Full stop. The learned single judge is rightly, therefore, negative the plea of the petitioner. Full stop. Having heard learned counsel for the appellant, the court is not inclined to the impugn order of the learned single judge, as it suffers from no material irregularity. Full stop. The writ appeal is dismissed.
Item 53. 17 days during COVID period.
What COVID period, sir?
Your Lordship may see that order.
Where's the COVID period?
Your Lordship,
when did you file the writ appeal?
This is filed on 16/10/2020. Order is 3rd February 2020. So it starts from 23 February 2020. COVID.
All right. What's the
17 days?
Okay, what's the challenge?
Direction to grant him pension in that. Your Lordship may see page 53.
Yes.
That we are agreed only with that refer. It has been directed to dispose under Annex 11 and Lordship may see that direction has been given taking into account.
What did you do in that order to that 276?
That relates to the different aspect. Those who are employed prior to 1/1/2005 and they have been granted pension. This is the case. He was engaged on 1/1/80 as BLR. Was brought over to regular establishment in 2019. So that is after NPS. He cannot be brought over to the old pension scheme.
What have you done the last 3 years? Not implemented this order. Because this writ appeal never came up for hearing.
First time it is. First time it has come.
So what has happened in the meanwhile? Did he implement the impugned order or not?
No.
Did he file a contempt? He didn't.
No, that's not. No contempt has been.
Show us that 20th November 2019 order.
20th. Yes, 11 and Annex 11 and 12 of the writ petition, my lord. Page in the writ petition, your lordship may see page 31. the read petition.
Writ appeal is no annexure 11. There are only 5 annexures. In writ petition, there are 11. Writ appeal 615.
Correct.
Writ appeal 615, there are only 5 annexures.
My document shows 44. Writ appeal.
No, I think we got the wrong one. The impugned order is 3rd February 2020.
You said for 20th November 19.
That is
there at 44.
And in my, I think it's at page 33.
Annexer 1. Oh, sorry. Annexer 1 contains entire.
That's different.
So there.
Anyway. So what is that? I mean, what is the difference between the facts in writ petition?
Yes, fact is different. Well, I have explained in my grounds, you can find it. That you also have seen that annexer 12 and annexer 11, my lord. In annexer 11, my lord, page 31 of the writ petition, you also may see that man, my lord, there are privilege of pension. We have not granted him pension. We have also granted him gratuity. He has also challenged that. That is also pending. That is pending in a separate writ petition. And this annexer 12, my lord, he entered into service in a pensionable establishment. He stands on a different footing. He is not similar to that this respondent, my lord. My grounds, I have taken that ground, my lord, that he does not stand in the similar footing with this respondent. That's para D, my lord, para E.
Yes.
Page 7 of my writ.
See, the present respondent in your matter is Banka Bihari Panda, right?
Banka Bihari Panda, he has compared with the Banka Bihari present respondent Durjodhana Mahakur.
Okay, Banka Bihari Panda is who?
He had taken the ground of that Banka Bihari Panda, which completely different from this respondent.
No.
Because Banka Bihari Panda entered into government service. And
but 20th November 2019 is not in Banka Bihari Panda's matter at all.
That is not, that I have taken, my lord, in paragraph D, my lord. That is Nabin Mandar. That you'll also see paragraph D of my writ appeal. In that case, that your lordship are directed to grant him pension and other benefits, but he is not entitled to pension. Accordingly, we have released his only service gratuity, and he has approved again this put in WPC number 1124 of 2020. That is also pending. And in respect of that annexer 12, he entered into service as against a pensionable establishment.
No. This Naveen Chandra Mandal is also in a pensionable establishment, is it?
Yes, my lord.
And the present respondent is not.
Not. He entered in regular establishment on 1/3/2019. That is, the NPS came into force from 1/1/2005.
All right.
So he is to be covered under new pension scheme, not under old pension scheme.
See, 1345/2020, it is explained that the delays on account of the COVID-19 occurred during the COVID-19 period. Accordingly, for the reason stated that the applications allowed the delays control. IA for dispensing is allowed. The main writ appeal is a notice returnable. May.
Item 54.
May I please, your lordships?
Item 54, my lords, pursuant to the last order, my lords, we have filed the affidavit, and my lords, the cost has also been paid, my lords. I'll just pass on the receipt.
It's all right, it's all right.
Yes.
No, it's okay. Where is your affidavit?
Please. It's at flag X, my lords. It's filed on 13th of December 2022.
This affidavit is, my lord, completely contrary to the affidavit earlier filed, my lord. Earlier, they agreed with the petitioner. In 2013, they filed the affidavit, for which your lordships passed the order on 21st of March 2022, my lord. My lords, may kindly see the order dated 21st of March 2022, my lord. In the reply filed way back on 5th August 2013, the state authorities had agreed with the petitioners that by combining Padampur and Paikmal blocks, great inconvenience would be caused to the present petitioners at Paikmal, as Paikmal is 40 kilometers away, making access difficult. The counter affidavit further states that the reorganization will take some time at the government level. The government is directed to file a further affidavit at least 1 week prior to the next date, explaining what steps it has taken for reorganization of the blocks, my lord. This is the your lordship's order, my lord. Now they have filed the affidavit. Your lordships may kindly see para 3 of their affidavit, my lord. Last part. Para 3, last 5 lines. However, since the process could not be completed by the year 2016, election was to be held in 2017. Hence, no delimitation activities could be undertaken at that point of time. That means in 2022 also there was PRA election, my lord. In 2021, they could have taken all the steps, my lord. They didn't take any steps since 2013 to 2022, my lord.
Now read para 4, sir.
My lord. That subsequently on 16/4/2022, another proposal was received from the Revenue and Disaster Management Department regarding the inclusion of Gram Panchayat of Paikmal block in Padampur block. Pursuant to the direction of the Honorable Court by order dated 21st March 2022 in WPC 8958 of 2013. It is submitted that in the meantime, the 3-tier PRA election to the said Gram Panchayat had already been concluded in March 2022, and the Panchayat Samiti members had been elected from the said Gram Panchayats. These elected members were part of the Gram Panchayats of the Paikmal block. Therefore, in the aforementioned scenario, if the Gram Panchayats under the Paikmal block, the candidature of the elected Panchayat Samiti members of the concerned Gram Panchayats will cease for Paikmal block. This will also have impact on the post of chairperson and vice chairperson who are indirectly elected by Panchayat Samiti members of the respective block, which will create further legal complications. Further, Jilla Parishad zone boundary, which consists of Gram Panchayats of a particular block, will also get affected. Copy of the note sheet. They have filed, my lord.
So they did it too. Because these are all elected Panchayat members.
My lord.
They'll have to vacate their seats, is it? This gets merged with the other block. There'll be no separate Gram Panchayat at all then.
Your lordships, in the earlier writ petition, my lords directed them to dispose of the repentation. They made the inquiry. The sub-collector made the inquiry. He found that yes, it will create great inconvenience to the people of these 5 Gram Panchayats, my lord. Because admittedly, Paikmal is 40 kilometers, far from these Gram Panchayats, my lord. And Padampur only 15 kilometers, my lord.
These are all matters of
that is why your lordships passed that on.
Administrative convenience.
My lord.
More problems.
Then in para 5 of their counter affidavit, your lordship, that in view of the above, it may not be prudent to reorganize the said blocks at this state. and this same may be considered before the next PRI election. But in the meantime, 3 PRI elections concluded, my lord. They did not take any steps. Now they are taking the stand that in the next PRI election, prior to that, we may do that. This is their stand, my lord.
I don't see what the court can do in here, sir.
My lord?
What? Here, there
Yes.
should be some legal basis to interfere with these decisions.
Honorable Court also passed an order, my lord, in respect of reorganization of Tahsil, my lord. Your lordship, my kind. 4 things are to be seen, my lord. The suitability. Second is the geographical location. Third is communication. And fourth is, my lord, availability of infrastructure, my lord. They themselves has filed the affidavit, my lord, saying that yes, Padampur is the easily accessible place for these people of these 5 gram panchayats. And so far as the geographical location is concerned, my lord, the sub-collector has filed his the inquiry report. Yes, Padampur is only 15 kilometers and Paikmal is 40 kilometers, which is that is also on the record, my lord. Collector also sent the letter to the opposite party number 1, stating that yes, Padampur is the suitable place. There is suitability, there is geographical location. Everything, my lord, supports the case of the petitioner, my lord. And I am passing the order of this honorable court. Your lordship may kindly serve. Give me a copy. Para 9, my lord.
Yes.
Mr. Ashok Parija, learned senior counsel, appearing on behalf of the petitioner, vehemently argued that refixing the headquarters of Bahanga Tahsil at Gopalpur in suppression of earlier notification dated 16/1/2009 on Annex 10, wherein the headquarters of the Tahsil was fixed at Bahanga, is contrary to the policy decision of the state government regarding creation of new Tahsil and fixation of their headquarters. The stand taken by the state government in paragraph 9 of the counter affidavit that Gopalpur was chosen in view of the geographical location, communication, and availability of infrastructure.
You can't compare like this. That's a different area, different factors. Each area will have its own peculiarities, sir. We just can't compare Gopalpur and Padampur.
No, my lord, no, my lord. Your lordship may kindly see I have filed everything. Annexure. That is, my lord, Annexure 4. Kindly, my lord. Page 70, running page 17 of your lordship's brief, my lord.
Yes.
Annexure 4.
Yes, yes.
This
We
is
have noted all this on the basis of this only they made the recommendation.
My lord.
But things have changed obviously now.
No, not changed, my lord. Because I belong to that particular Gram Panchayat, my lord.
Now
That's my lord. I belong to that particular Gram Panchayat, my lord.
That's the point.
My lord. That's not the point, my lord. I know
That's
what is
why it's public interest.
No. 5 Sarapanch of these Gram Panchayats have come and filed the PIL, my lord.
Right.
Yes. I am placing the third, your lordship's may kindly say. The people of locality would have to.
Legal issues. That's a problem.
It's a legal issue, my lord.
What is really a political issue is being converted to a legal issue. That's the
problem. My lord.
It's essentially a political issue. You convert political issues into legal issues, there will always be problems.
It's not political. It's the issue of the people of 5 Gram Panchayats, my lord.
Correct. See, drawing boundaries, redrawing boundaries. If you see the constitution, even on delimitation,
and they have also filed.
There is a great restriction on courts interfering in these kind of processes. Have you seen this? Article 329.
My lord. in that matter, my lord, court has interfered, my lord.
Actually, very limited scope for interference, unless it is malafide and all of that.
There is malafide, my lord. Because again, I am taking your lordship
Again, it has to be
counter
pleaded.
affidavit.
Yes.
They are counter.
Not simply casually say it. Yeah.
They are counter affidavit. That is at page. They have filed the counter affidavit on 5/6/2013, my lord. Para 6. Your lordship may kindly see. This is the counter affidavit filed by the collector, my lord.
Correct.
Para 6.
Right.
Sub-para, my lord. Running page 2 of their counter affidavit.
Yes.
It is humbly submitted that in obedience to order that so and so. Last 5 to 6 lines, my lord. The Paikmal Tahsil headquarters is around 40 kilometers away from Lakhamara, Chodapali, Soraikela, Badikota, and Bukramunda Gram Panchayat area. Further, I stated that Padampur Tahsil headquarters is only 15 kilometers away from the aforesaid private Gram Panchayat area. Besides, there is only one all-weather road from the above areas to Paikmal, which runs through via Padampur, which is not only a top quarter, but also a subdivisional headquarters. People of the locality will have to cover more distance to reach to Paikmal than Padampur. Soon after receipt of the report of the sub-collector, Padampur, the collector Berger immediately wrote a letter to the additional secretary to Government of Orissa Revenue and Disaster Management Department on 4/3/2013, stating therein that proposal for merger of petitioners Gram Panchayat of Paikmal block with Padampur block may be considered for convenience to local people with concurrence of PR department, my lord. There that is where they took time and they sought for time and stated that it will take some time.
Took time to change their mind. In fact, that last line of this affidavit gives you an indication they may again change their mind.
They cannot play hide and seek game with
this is
all the
politics, sir.
petitioners, my lord.
This is politics. That's the whole thing. That's why I'm telling you. You're trying to convert a political issue to a legal issue.
And also,
these are not matters. All right. You see the issue concerning merger of the Paikmal block with the Padampur block is the subject matter of the present writ petition, which has been pending here in this court since 2013. Full stop. The stand of the state government expressed in an affidavit filed on 5th August 2013 was noticed by this court in its order dated 21st March 2022, which reads as under, reproduce the order, paragraph. Despite 2 adjournments, the affidavit of the state government was not forthcoming. Stop on 7 December 2022 was passed. Paragraph. Today, the matter was called out. Mr. Mohanty, an additional standing counsel, informed the court that the costs imposed on the government have been paid. Stop. The affidavit was also filed. Stop. The latest affidavit dated 13th December 2022 reflects the changed stand of the government. Full stop. This changed stand is evident from para 4 and 5 of the said affidavit, which read as under paragraph. Mr. Counsel petitioner Mr. G.N. Sahu, learned counsel, appearing for the petitioner, voices exception to the changed stand of the government. Full stop. He refers to the earlier recommendations on file made by the sub-collector and the collector, on the basis of which the earlier affidavit accepting the proposal of merger. Stop. He submits that there is no basis for now changing that stand. Stop. He refers to the decision of this court dated 21st August 2013 in its petition civil 25280 of 2011, bracket Sarath Kumar Raj versus State of Orissa, which is in the context of fixing the headquarters of the Bahanagar Tahsil in the district of Baleshwar. Full stop. He urges, therefore, this court should allow the prayers of the petitioners and order the merger of the Paikmal block with the Padampur block, as originally recommended by the state authorities themselves. Paragraph. The difficulty in accepting the above plea is that questions regarding merger of administrative blocks or redrawing boundaries are best left for the decision of the state authorities. Full stop. Even in Sarath Kumar Raj versus State of Orissa Sutra, the limitations on court's interference in matters of this nature was noticed. Full stop. After noting the decision of the Supreme Court in State of NCT of Delhi versus Sanjeev alias Bhetto, AIR 2005 C2080, this court observed as under A to A. Ultimately, this court, even in Sarath Kumar Raj, constituted another high-powered committee to examine the issue and did not itself issue a mass allowing the petition. As far as the present case is concerned, it does appear to this court that the reasons explained in the last affidavit filed by the government, but the difficulties in ordering the merger of the two blocks at this stage cannot be said to be unreasonable, shaded by malafide. Full stop. The court does take note of the statement in the affidavit that the decision regarding reorganizing of the blocks will be considered before the next PRI elections. Full stop. In that view of the matter, the court declines to grant the reliefs as prayed for in the present petition. It is accordingly dismissed.
How Tahsil office is working at Padampur, my lord. Whether it will go to Paikmal, my lord, 40 kilometers. That should be clear, my lord, because this is the
These people have very good SUVs, sir. Now, all your panchayat members and all have SUVs, cars.
Not a single car
Roads
have
are
taken, my lord.
The roads are very good.
No road, my lord. There is no bridge to connect to this Gram Panchayat till date, my lord.
So you work on that, sir, that you approach them for that. That is where you're
Government is just like a dead wood for the people of this Gram Panchayat. Yes, my lord.
So you make efforts in that direction. In fact, when there are petitions filed for those things, for not
Yes,
making
sir.
road and all, we are issuing
Yes,
directions.
there is another PIL filed by somebody else, my lord. Yes,
So,
my lord.
so that will like entertain those kind of things. See, improving infrastructure and all that we can always ask them what are they doing for that. In fact, we have been asking them to present videos showing us whether actual work has been done. When roads have not been constructed, we've been issuing directions.
Now the bridge is going to be constructed. It will be completed in 2025, I think. Now.
All right.
Urgent copy, man.
Okay. All right.
Item number 55.
Item 55, my lord. In lordship's order dated 23/8/2022, we have filed a fresh affidavit yesterday, my lord. It is regarding that the compliance report of all the departments have they completed the work on. That is under annexed D series, my lord. We have it's the compliance report of all the departments under annexed D series. And this is an ongoing process. So every year work is done and every year report is we have annexed.
All right. All right. Pursuant to the order passed with this court on August 23rd, 2022. An affidavit has been filed by the Registrar Ravenshaw University. Placing on record the status of the repair renovation work in the respective departments and the year-wise list of works undertaken. Full stop. The court is assured that the repair and restoration work of the university is being undertaken open continuously as per requirements and as to funds. Full stop. Unquote. Placing the said affidavit on record, affidavit and statements on record. The writ petition is disposed.
Item 56.
May I please, your lordship. This is a public interest litigation, my lord, wherein, my lord, the petitioner pays for a direction to the opposite parties to take care of the public parks and playgrounds of the Kotak city. Last time, your lordship directed the council for CMC to file their counter.
Well, some parks in the CDA area of the CDA, some parks to the municipality. My lord, I'll seek some time, 10 days time, my lord.
Last time also you thought.
My lord, I know I am at fault, my lord. I know I'm at fault. I have sought for instructions, my lord. Kindly one accommodation, 10 days, I'll file an affidavit to that effect.
Mr. Nayak seeks more time for instructions. At his request. It's done. 21st February.
My lord, I am for the opposite part number 3, my lord, on behalf of Mr. Dhananda Mahapat.
Item 57.
57. My lord, may kindly pass over. Mr. Samantray will come. Just.
Or
Item 58.
58, my lord, the counter and rejoinder have already been filed, my lord. I seek some more time, my lord. Mr. Das will argue this matter. This is relating to the accident, my lord. We are challenging the amendment to section 166 clause 3.
He said the request of Mr. Dash and consider petition. List on Fifth April.
Obliged.
Item number 59.
May I please, Lord? This is a PL regarding providing food security to the non-ration card holders as well as non-Aadhaar possessing people, my Lord. Now, in course of on dated order dated 28/3/2022, there was an order in paragraph 3. It is mentioned that Mrs. Patnaik, an additional government advocate for the state, on instruction state that government officials would like to make a presentation to the court of the steps being taken by the state government proactively to increase the coverage of the beneficiaries under the central scheme and the state-sponsored schemes. And to that effect, and order was issued, the officials of the government made their presentation in online mode on the next date. But this order is yet to be complied. But once they present the areas they have covered as on date, things should be more clear, my Lord. Ought to have been presented, but if it is not, kindly give some time for compliance of that one.
But the last order,
yes,
the survey reported to be handed
no,
over.
that is, I have already solved. Yes, I have seen.
All right, Mr. Jaina, learned constitutional petitioner, draws the attention of the court to the order dated
Was it 8/3/2022?
Yeah, 28th March 2022, which notes the submission of the learned AGA that the government officials would like to make a presentation to the court on the steps taken by them to increase the coverage of beneficiaries under the central and state-sponsored schemes. Mr. Manthi, learned AG, undertakes to arrange for such a presentation in online mode on the next date. Full stop. 1st March?
1st March or mid of the March.
14th March.
At 2 p.m. it may be posted. So that
at 2 p.m. All right.
Item number 60, there are two developments. One is this letter of the government. I have obtained the instruction. I'm just reading before your lordship. In copy. It is copy. In continu, this is addressed to the Advocate General. In continuation to the letter under reference, I am directed to intimate that the tentative draft Odisha Appointment Ownership Bill has been returned by Law Department. As a part of the established procedure, the draft cabinet memorandum along with its annexures has been placed before the government for according kind approval and for placing the same before the Honorable State Cabinet. The aforesaid position has been submitted for your kind reference. So Law Department has already vetted it and it will just place before the cabinet. Then
give us some time.
And so far as the IGR matter is concerned,
no, but give us some time estimate, because this has to then be placed before the assembly, right?
Either it will be placed before the assembly or there will be an ordinance if any urgency is. Otherwise, assembly, I think.
Don't say if any urgency. Look at all of them. We're all desperately waiting.
Now, once it is placed before the state cabinet, it will decide, keeping in view the urgency or something. They will decide, the legislators, the cabinet will decide that whether it will go to the assembly or any ordinance. That not submission on that. It is the prerogative of the state cabinet rather. And so far as that other issue is concerned, we have already issued a corrigendum.
That is all.
That is there.
Yes.
The corrigendum I may submit is not in accordance with your lordship's order.
They have inserted some words which was not there in their affidavit. Every time this thing happens, and
This is,
I'm sorry to say, it's not in accordance with
this
your
is in
lordship's
letter and spirit of this honorable court's order.
No.
If my lord, yes, if he has got any grievance, he may file a application.
My lord, I have a simple issue that the completion certificate has to be issued by the competent authority. Let the state learned AGS say who is the competent authority. This much only, my lord. I only
That
have
is
this
already
much of
declared in
query
the
of your
rule.
lordship.
Who is the competent authority that is provided
My
by
lord,
law itself.
exactly. That is a whole confusion lies there, and they are taking benefit of that confusion.
There is absolutely no confusion.
Then let them state it. That should be cleared. Exactly.
Confusions are being created by the petitioner here.
No, not at all.
Law is not at all confused.
Let the state government clear it. Who is the competent? Everyone will be satisfied.
It's defined.
That is what my
section 2 coining a new
2P. Who is under 2P? Let them state that I will be satisfied. At least everyone will be satisfied. Everyone will be satisfied.
My lord, your lordship kindly goes to the order.
Only your lordship, one word. Who is the competent author? Let them state it.
No, that has been answered by the Honorable Supreme Court, my lord. The last new text judgment, which, my lord, your lordship may kindly, that has already been answered.
No, nothing. There only completion certificate has been defined. Completion certificate will be issued by the competent authority.
By the Honorable Supreme Court, declared by the Honorable Supreme Court. You can sit in.
May I pray one thing to let us not make any controversy on this. We cannot act according to the sweet will of the amicus or Mr. The petitioner. If he has got any grievance on this, let him come out with a petition. We will respond to that.
No, that is already my lord. That corrigendum which they issued is contrary to the own clarification issued by RERA. I'll just
my lord, I have advised them to withdraw that clarification. No, they had done that earlier. In view of the recent development, what has taken place, I have advised them to withdraw it, and I will also file an affidavit.
They are issuing contrary clarifications, and it is creating a whole lot of confusion. I only pray that who is the competent. Let us know. The people of the state are at least entitled to know who is that person, who has issued that competent authority.
My lord,
public interest litigant. Yes.
Interest litigation.
Yes, it may be. For you, it may be private interest litigation.
Public interest.
For you, it may be private interest.
It's all right.
He is not holding a placard for the whole people of the state. But it's a purely private.
So it is my humble prayer that let the state should only indicate who is this author, where a person should go. The whole confusion will be sorted out. I am trying to sort out this confusion. My lord, I am only trying to sort this confusion. Is the state so incompetent to say who is this person?
My lord,
I'll not say anything more. Let the state say who is this person.
My lord, all these confusion are all manufactured confusions.
Then you please.
No person is aggrieved. He may file a single affidavit who is deprived of getting the justice because of this corrigendum of the government. There is no such example.
Let them just state who is the authority.
Yes. Clan has not filed any affidavit.
I do not want to further.
You can make any submission without any affidavit.
The state is there. They are even your lordship now. They are not saying who is this competent authority.
No, we have already.
Even when the hearing is going on, they are not saying who is the competent authority. Now, what that, my lord?
Say
exactly, your lordship.
In the law, it is there in the law.
It's all right. Also, tempers have to be cooled now.
No. By this process,
the weather outside at least doesn't warrant this. The weather is pleasant outside. So I don't know. Well, in fact, on the last occasion, it was understood that these cases have to be dealt on a case-to-case basis. So that was what was the understanding on the last occasion. And para 7 of the order also specifies that.
Mr. Agarwal, in case there is any confusion, it might, like Mr. Mohanty is suggesting, you put it down in an application and deal with it.
I have already filed an affidavit to that effect. My lord, just
copy has been solved on.
My lord,
no copy has been solved. Who has filed? You have filed
a statement. Let it be a submission.
There is only earlier.
Read petition be hard on merit. We're prepared for that. Let it be hard on merit.
Yes. So much of anxiety, so much of fear, so much of fear. I don't think that anyone is having any fear.
I don't think that anybody is having any fear.
This is
It's like he's creating a fear psychosis in the mind of everybody.
You should not say like this.
Afraid of you.
Who is fearing?
All right, then you please allow me to submit.
Please, yes.
Now, my lord, here I would like to
let him withdraw this one.
Mr. Acharya, just let him finish the submission. Mr. Acharya, let him
Allowed to
finish.
say like this.
Yes.
Please control your tongue.
All right. Yes.
Now, my lord, I have in my affidavit dated 2/12.
I have not received any affidavit.
I have already served you, sir. 2/12/2022. It was served. It was there on the last date. I have indicated why this confusion is occurring. I have given some documents, some examples. This confusion is occurring since they have included the word.
Now that the corrigendum has come, let's look at post corrigendum. What confusion is there? If there is any such thing post corrigendum, like he's suggesting, you fill an application.
I'll bring it before your lordship.
Mr. D.K. Mahathi, learned additional government advocate, has placed before the court written instructions received by him.
H&UD department.
Yeah, from the Housing and Urban Development Department that the tentative draft of the Odisha apartment ownership and has now been placed before the government for in turn being placed before the state cabinet. Full stop. Paragraph. A copy of the corrigendum dated 22nd December 2022 issued by the Inspector General of Registration, Orissa. In terms of the order passed by this court.
Pursuant to the order of this.
On 7th December 2022 has also been placed for the court. Paragraph. Mr. Mutagwal and counsel petitioner states that if any difficulty is now encountered after the corrigendum, he may file an application seeking
by any person. By any person. Yes.
He may file an application for appropriate directions. Full stop. List on.
That we have revenues.
22nd March.
Obliged.
Before that, let it be finally hard. Because this enactment of law is a separate chapter altogether. Just a minute. It's another chapter, Mina. That may two issues, as I have understood. One is the formation of an association or body, whatever it may be, of the owners. And the number two is handover of the common area. Those things, as the state, that's the prerogative of the state whether to come out with a new law or to go by the. That's the prerogative. We are not into the domain for the time being. But so far the pre-RERA constructions are concerned, clearly they do not come within the ambit of the 2017 Act. Lots of confusions, what I understand, are being created. That no, this registration, completion, etc. That is why I would request my lord to go through this new text judgment, which last time also your lordship went through it. These issues have already been answered. So para 32 we were reading out the other day that has not that prior to RERA there was no law. There was a Development Authorities Act in Orissa, which is prevalent since 1982. There is another Apartment Ownership Act which also takes care of it. Your lordship is right. So far the new regulation is concerned under the RERA Act, whether these associations are to be formed in conformity with Section 17 or a new law to be enacted by the state, that's a separate chapter. But so far the registration part of the old buildings are concerned, which are not coming within the ambit of the ongoing projects.
The addendum, sir.
So that's correct. So therefore,
one doesn't need to add anything to that now.
The alertees are also suffering. The builders are suffering, the alertees are suffering, everybody is suffering. That is the issue. Correct. So let the read petition be heard, on merit.
All right.
So the prayer, no, your lordship may kindly appreciate. That is because the three prayers he has made. Your lordship may kindly have a glance at
not
the
necessary, sir. We fixed a date, we'll hear you on that.
No, that's correct. Yes. So therefore, March would be too long. So before that, your lordship, the corrigendum, the IGR has issued. So the clearly, most of the sub-registers, DSRs are
Mr.
also...
You can take it from me without seeing the actual act in. I'm not going to dispose of the writ petition.
No, but that is correct.
Don't even suggest that we should somehow hear and dispose of these writ petitions without that act coming out. That will not happen.
That's a clear.
That certainly will not happen.
Legislative domain.
That will not happen. Don't attempt that. We will definitely finally hear this writ petition, but not with that act still in the preparatory stage. Yes.
My lord, subject to your lordships, I don't want to put words into your lordship's mouth.
Yes.
But so far as this ordinance or whatever the bill they are coming up with the state government. So we are not, my lord, only that if your lordships can, I won't say there can be a direction. If your lordships can say that we expect that it can come up at the earliest.
No.
Because then this
That will have a different context.
Otherwise, because we don't know when the next cabinet or the assembly say.
All right. That the law, that is very clear. You know that better than anyone else, Mr. Nanda. All right.
My lord, because the last occasion, as your lordships knows, that they had to curtail it earlier so that this was supposed to be taken up on the last occasion.
That framing of law, your lordship knows that. How does it all depends. It's their domain. No, let them frame a law. We are not opposed to the state for coming out with new law, with new legislation. That's a separate chapter, my lord. We are not on that. But for the time being, my lord, what we are praying, so far the writ petition is concerned, the other part that is post-rera. Pre-petition, my lord, that has to be taken care of. So everybody...
Fix a date, sir. We'll hear you on that date. We'll hear you on that.
Item 61.
Let the petitioner here, that's writ of quorum 2, my lord.
Yes.
Lord Lordship would kindly see the last order passed by Lordship 8th of December 2022, and then today we are on final hearing of the matter. Now we'll
take it up at the end of the board. There's only some 7-8 matters.
Your Lordship.
Item number 62.
Here, opposite party number 1 and 2 have recovered the service tax from the petitioner when there is a duty casted on reverse charge mechanism. The work order was in the month of March 2012. The reverse charge mechanism was introduced from 1st July 2012. But they have recovered their 50% part from the petitioner. So for that, we have approached. There is a settlement of dispute agreement.
So you avail that, sir. You avail that. Counsel of the petitioner seeks leave to withdraw the present petition with liberty to seek the remedies available to the petitioner in accordance with law. This post of is withdrawn with liberty is break.
Item 63.
I am appealing
for the MCL.
There is another
party 1 and 2.
Another matter of the same petitioner.
Yes.
5193 of 27.
All right. That's taken on board.
Only the page number has to be changed. 67. 15.
Yeah, we don't have quote the clause. Sir. It's all right. Yes.
Obliged.
Same order.
Item 63.
May I please, let's. In the first item, I have filed the rejoinder, but my learned friend needs another copy of the rejoinder.
I have not received the all right. Copy of the
In the
rejoinder.
first case. And second case, let's say my learned friend has not filed the counter. Department has not filed the counter.
I have filed. FCA has filed
No,
the
in the
counter.
second case, Surya Construction.
So far the service tax department is concerned, I
He
pray.
has.
Cases are different.
So department is to file counter.
The second case.
Yes, sir.
All right. In writ petition civil 37486 of 2020, the rejoinder be served on counsel appearing for respondent
Copy number 4 and 5.
opposite number parties number 4 and 5. In writ petition civil 26479 of 2019, counter affidavit be filed by
Department, service tax department.
the service tax department within 4 weeks, rejoinder before the next date. List on 15th May.
Mellow.
15th. Item 64.
64, concerns reversal of input credit based solely on annexed.
64. Your Lordship, it is against that fast appeal order. Your Lordship has already issued notice. Your Lordship, 4 weeks more time may be granted for filing of claim.
Lordship, may I make a submission, Lordship? During the pendency, on the basis of the 48 GST Council's meeting, on its recommendation on 27 December, CBIC has issued a circular addressing the very issue where the grievance of persons placed like me, where the input credit was being reversed and that it's not appearing on Form 2A. Mechanically, it was being done. The many representations were made before the central government, and on consideration of those representations, the GST Council recommended to issue suitable guidelines, notifications issuing suitable guidelines for the proper officers to follow before rejection of the or reversal of the input credit mechanically. So they have laid down a guideline, detailed guideline addressing different situations in which a input credit might be a person may get denied of the input credit, and that if Lordship permit, I may.
So do you want to withdraw the writ petition because
no,
of that?
No, Lordship, no.
Will you want him to file a reply or you don't want him to file a reply?
All right, Lordship.
Thank you. Counsel for the East Department seeks and is granted 4 more weeks time to file a reply. Reserved up for the next date. List on 16th May.
Item 65.
We have just been served with the counter affidavit.
All right.
Under some time.
Rejoin to be filed for the next date. Interim order to continue. 17th May.
Item 66.
Item number 60.
66.
67. Both your Lordship, I may be permitted 4 weeks time to file counsel.
May I just state, Lord, sir? There's a similar matter that is WPC 22683 of 2022, where Lordships have been pleased to post it to 20th of March 23.
All right.
So this matter may be 20th March along with WPC 22683 of 2022.
All right. You see, Counsel for the Department seeks and is granted 4 more weeks time to file a reply. Rejoined up for the next date. Interim orders to continue. List along with 22683 of 2022 on
20th of March.
20th March 2023.
The second item.
Same orders.
Same order. 67 orders.
Correct.
Item 68.
Made legal Lorships. The revenue was supposed to file a counter.
Passover. What about
Lordship may kindly see the order dated 5/12/2022. Lordship, kind remembrance, this writ petition along with a batch of writ petitions were listed on 1st of December 2022.
I beg pardon, my lord. In this case, I require to file an additional affidavit in this case. Because my lord senior had raised some questions and Lordship allowed me. That could not be filed.
Let him file the affidavit. But what so another so-called Lordship, remember that day, too much of natural justice. Lordship worded this. So the too much of natural justice. So what is that which prompted, and also that let them produce the records, because they cannot let their whims and caprice go on issuing notice.
All right. Mr. Mahapatra undertakes to file a further affidavit and also produce
the records
on the next stage.
Yes. Lordship may fix.
Mahapatra learned senior standing counsel of the department. All right. So you wanted this side of the vacation or the other side of the vacation?
Beg your pardon,
this side of the summer vacation or the other side?
Some other by mistake, 2 other writ petitions also were segregated, but again has been mixed up.
I see.
So I have filed a review petition.
Oh,
matters.
I see.
To just
desegregate that.
Segregate matters. Much obliged. Interim order to continue.
10th May, interim order to continue.
Much obliged.
Item 69.
69, item number 69, a short date may be given your Lordship on the last occasion issued notice and directed to produce record and call for the instruction, your Lordship. Your will call for the instruction and also the original record. Your Lordship, a short date may be given.
This is already covered by your Lordship's judgment in Keshav Automobiles.
Yes, yes, I'm well aware about that. But,
so that is the reason why your Lordship's on 22nd of November
caught the record.
Your Lordship, one chance, last chance.
All right. At the request of Mr. Mishra, who needs some more time to produce the record. List on 11th May.
May I pray for an earlier date now? Because
3rd May.
Your Lordship is well aware about the record, Your Lordship, but
it'll be sometimes in February, because Your Lordship, I've seen various records of this type.
I also
but it's all heavily blocked. Okay, 14th February.
14th February.
14th
Much obliged. The interim order to continue.
Interim order to continue.
Your Lordship, may pardon me, the 66 and 67, where my learned friend took time. There are interim orders also. That may also 66 and 67.
Interim order to continue. Right.
Greatly obliged.
Right.
Item number 70.
Item 7, my lord, covered my lord.
On covered.
Then
covered. They can say
illegal demand.
This.
All same one.
Item 71.
71, my lord, that is covered. That challenge the demand notice issued by the Odisha State Beverage Corporation.
Yes, all right, same order. Same order, same order.
Item 72.
72, similar to item number 70. Milord.
Similar to?
Similar to item 70. Milord. I have
70. All right.
73.
Milord, I have given the order. Milord. The same order only Your Lordship are having.
Right.
my lord, on behalf of Mr. K. Guru, item 73 become infructuous.
All right. Dismissed as infructuous. All right.
Item 74.
My lord, respondent corporation has also filed an appeal 314 of 2020. Let both the matter be taken up together.
Okay, list along with writ appeal 14 of 2020 on
314, my lord.
Okay, 314 of 2020 on 9th May.
Item 75.
Yeah, please, Your Lordships. The order of the Honorable Single Judge.
Really?
I have challenged my lord 2011-2019. This is
R3 was not served, insufficient address.
The address was there, but what was there in the cause title of you?
What to do?
I can take a fresh notice, my lord. If my friend, my lord, can provide me that address, because he's appearing for opposite partner 1 and 2.
This is what, surfacey matter or something?
No. It's a case
service
of
matter.
Yes,
service matter. Pension. But Indian Bank is what? Nationalized Bank.
Pension, my lord, was denied to him on the date of application, my lord. I have not submitted the amount to be refunded so that I can get pension. Only that is the sole issue. And though I have cited a judgment of the Bombay High Court, my lord, exactly on the same issue, same principle, my lord. But Honorable Single Judge, though referred to that.
167 days delay, sir.
But according to my application, my lord, there is no delay because I have applied, my lord, on 1912 and filed, my lord, immediately on 6/1 on the next year, my lord, next 1912-2019, my lord, I got the certificate. And because of the vacation.
All right. For the reason stated, then the delay is condoned. That IA 76 of 2020 is allowed. In the main writ appeal, you say fresh notice to. You say the respondent 3, notice to respondent 3 has been returned unserved with the remarks single quotes insufficient address. The appellant will ascertain the correct present address of respondent 3 and file thereafter a fresh notice be issued. That address to respondent 3 returnable on the next date.
Within 1 week, I'll file.
All right. 2nd May.
Item 76.
Item 76, Your Lordship. On behalf of Mr. Bimbisa Das, Senior Appellate Counsel, may I pray for next week? In fact, his son is personal difficulty, Your Lordship. The son is quite ill.
All right. Counsel for the appellant is stated to be in some personal difficulty. 3rd May.
Obliged.
Item 77.
Memo of withdrawal has been filed in this case. Item 77.
The memo is taken dismiss instructions. All right. All right.
Pastor matter item number 38.
No, there are 79 and 80. 1 minute.
Item number 38, your lordship. Item number 38, the appellant got his national permit.
So it's in
Hence,
purchase.
yes, got his national permit, hence it may be permitted to withdraw.
All right. Counsel for the petitioner seeks leave to withdraw this petition. Disposed of as withdraw. All right. 38 is over.
Item 57.
Yes, he has that.
It's 4 o'clock, sir.
Sir, as per your direction, I have given the report.
And where is that?
And prayers are very simple. I don't think the government will oppose those prayers. I've given the copy.
Where is that? You have filed it, sir?
Yes, ma'am.
When?
3 days back. I have a copy also. And better copy.
Okay.
Sir, page 8.
Suggestion page 10
Facts are not disputed. Prayer is also not disputed.
Suggestions. You are disputed.
Recently, there was a report, Mr. Samantara. There's a report about Anugul.
Yes.
Many of the posts are vacant in Anugul.
Yes. If you also kindly come to page 10, suggestions my friend has given. I will go through all the suggestions, and come up with a reply which you can immediately comply and which will require time. If you also kindly come to page 10 of that affidavit file, note given by my petitioner. He has prayed that direction may be given to fill up all sanctioned posts in government hospitals in the district be filled up within 6 months. And then new posts as required by the created CDMOs. In all these sessions, I will go through, talk to the officer, and I will come up with a reply whether how much time will be required and what will be steps taken by the government so far as
Kindly have a glance on page 8, man. Facts. They are disputing facts, but the facts are as per the report of the DLS committee.
It will be with the banks. Right? Yes. What?
This is the bank. That's the main. This is access approval on this bank. Okay. Access agreement. Bank.
No, this man himself visited, see page 5. We read from 5 onwards. He has himself visited personally some of the PHCs.
Yes.
He's finding it's all non-functional. The petitioner who appears in person has filed a note analyzing the various reports submitted by the DLSAs. Stop the what the petitioner found in his personal visits, some of the PHCs and CHCs in and around Cuttack, Shashpur, and Jagat Singhpur. He has given a series of suggestions on what should be done immediately. Mr. Savantral, an additional government advocate, states that they will examine the note submitted by the petitioner and respond to the suggestions given by him on the next date. Stop. Now that the government has the full facts before it, it should take the corrective measures without any further delay. Stop. The court would like to see actual tangible change happening on the ground in respect of each of the matters pointed out by the petitioner in his note. Stop. Filed by the Additional Chief Secretary Health, specifically indicating precise action taken in respect of each of the suggestions given by the petitioner in his note. The affidavit be filed at least 1 week prior to the next date of hearing. February 15th.
Let the next PL minor come after 1 week. I'll give photographs. They are not giving photographs.
Okay.
That section of the road that was creating a problem has been now completely shut down because of the expansion of the medical college.
Blocked, my lord.
That there is no approach road from there, so there is no question of traffic congestion. But my lord, I'll file photographs along with an affidavit. I'll file that.
Now nobody can go to Cancer Institute without RUS. That is the development they have made.
Okay.
Let me be allowed, my lord, to give photographs.
Yes, please. You file your affidavit.
Item number 78.
I may be allowed to place the matter on behalf of Mr. Ratha for the petitioner's matters. In pursuance to your lordship's directions, I have filed the detailed written notes of submissions after serving copy to the other sides, madam. 30/12/2022.
You got the note.
No, your lordship, copy, I have not received any copy, but I can also file. If your lordship, if your lordship will permit to argue the matter, then your lordship, it can be argued, or your lordship only filing of written notes of submission, I can file the written notes of submission, your lordship.
Yes, yes. You file your written. You said the petitioner has filed its written note of submission. Mr. State, he will also file a written note of submission for the next meeting.
Your lordship, I am filing the written notes of submission which may be accepted.
Oh, Mr. Mishra has handed over the written note of submissions in court today. 23rd February.
Your lordship.
23rd February.
Your lordship.
Okay.
May I pray, madam? Mr. K. Ratha name may be added.
All right.
The order sheet.
All right.
Obliged.
79.
In compliance to the interim order passed on 29/11/2016, petitioner complied the same by depositing the
All right. No questions have not been framed.
My lord, question of law is at page 18. Whether on the facts and in the circumstances of the case, the tribunal was legally justified to tax tire, tube, and flux when sold, along with tractor trolley as a single unit, to be taxed separately at the rate
This is already decided, not tractor trolley. We just decided the other day.
No, lordship. Your lordship, it is different, your lordship. The entry itself is very much clear. Your lordship, you may kindly turn to page 51. That entry is there, entry number 119. The entry itself excludes tires and tubes, your lordship. So as per the entry, the tribunal, the London tribunal has passed the order.
No, I'm not a retailer of tire tubes. I'm sold tractor trolley as a single unit, my lord. I'm a manufacturer. I'm a retailer of tire and tubes. I'm a manufacturer of tractor trolley. I sold the tractor trolley along with tire in one unit. Can this assessing officer bifurcated system to different tax? When tractor is sold, it is 4%.
Finally, turn to the finding of the tribunal, London tribunal, at page 51. How the appeal gone through the impugned order of appeal and the order of assessment, so and so. The main contention of the appellant revenue is that, as per entry 119 part 2 schedule B of the OBAT Act, tires and tubes are excluded from 4% taxable goods, hence are taxable at 12.5. It is the unscheduled goods. That the London Review was correct in his assessment. On the other hand, the London advocate for the respondent sternly argued that he is the manufacturer of tractor and trailer as a single unit of tires and tubes are integral part and tractor. The integral, your lordship may kindly read paragraph 6. In the events of private contention, it is now decided at his forum whether tires and tubes in a tractor trolley are to be taxed at 4% as per entry 119 or part 2 of schedule B, or are to be taxed as unspecified goods as per schedule B part 3 of 12 at the rate of 12.5% or 13.5%.
Just imagine, sell a tractor without tires and tubes. Can it run on the road?
Your lordship is absolutely right. But your lordship, the entry itself says that excluding, your lordship, in whole, tires and tubes, so and so are unscheduled goods. But your lordship, entry says tractors, tracers, harvesters, and attachments and parts thereof, excluding, your lordship, the language is exclude tires, tubes, and plugs. Your lordship, tires and tubes are unspecified in toto. Your lordship, that is the, your lordship itself, when entry is that, the intention of legislature is very clear, your lordship. So your lordship is saying that without tractor, without tire and tube, tractor cannot run. But your lordship, entry and the authorities are abide by that entry, your lordship.
This is my depend upon my lots. Without, can the tractor run without tubes? Similarly, I am selling in one unit, single unit, not separately.
It's like you have to bill it separately. That's what it means.
No, I'm not billing separately.
So you should. You'll anyway pass it on. Maybe higher incidence of tax on the tire and tube, and will pass it on. No. Ultimately, the customer is paying for it.
No, I'm selling in one bill.
But I know you'll raise two separate bills. One for separate.
When tractor sold, can the dealer of tractor selling the tractor separately start tire tubes for tractors? For the crop selling, can they run without tire?
That's what I asked him. The point is that the entry itself excludes. That's the whole problem. You have to challenge. If you don't challenge the entry, then they have to apply it as it reads. That's the whole problem. Okay. It's dismissed. We pass the detail.
As a sub item is similar, and I also complete the order by paying.
All right.
79 and 80.
79 and 80.
One more matter, item 60.
Please,
item number 61.
If your lordship are not done for the day, Lord, I'll request your lordship. If not done, then I can argue the matter, my lord. Otherwise, my lord, sometime 2 p.m. next week, my lord. Otherwise, my lord, it gets infructuous, my lord. Lordship may kindly appreciate. 8th of December, lordship's order is there.
Many years back, my lord, as a young counsel, I was appearing before Justice Ansaria, and I was the state sales tax department lawyer, and batch of appeals were posted. So one appeal got over at 4:13. So my matter was called, and I told his lordship, your lordship must be tired. He said, we get tired at 4:15.
I also not want to inconvenience your lordship, my lord. So sometime 2 o'clock next week, any day, my lord.
17.
Lordship.
Okay. 17, 2 p.m., my lord. No, otherwise, my lord, your lordship will get similar situation will arise, my lord. I'm sorry, my lord. I am saying like this.
No. All right. 17, 2 p.m.
2 p.m. I'm deeply grateful.
All right. Okay.